Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting and bossing within the Commonwealth. Run here, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone, and welcome to this sitting of the Appeals Court. My name is Amy Blake. To my right is Gregory Massing. To my left is Catherine Hand. We are your panel for the 5 cases that are on our list today. I'm sure most of you have been here before, so very briefly I will go over the rules. Each side is permitted 15 minutes. I'm aware that one of our cases is dividing their time. There is no rebuttal. I can guarantee you that we have read all your materials, so it's best to get right to your arguments. With that said, we will call the first case, which is Commonwealth versus Brian Kelleher, docket number 22P522. Counsel, good morning.
May it please the court, my name is Murray Kahn, and I represent Brian Kelleher on appeal of his convictions for trafficking and intent to distribute. The question before the court today is, did the evidence show that my client was under threat of harm by Darwin Soto and his drug suppliers so as to justify giving the jury an instruction on the defense of duress, and whether the absence of that instruction created a substantial risk of a miscarriage of justice?
Okay.
The answer to these questions is yes.
Justice Hand has a
Sorry,
question.
Counsel, can I ask you this? Can you clarify for me what the threat is at issue here?
Excuse me?
Can you clarify what specifically is the threat that Mr. Soto made?
Well, when we talk about threat, it's, I believe the case law, and specifically Justice Jacobs' thoughtful decision in Pearls, indicates it's not so much a verbal threat, a verb, but a noun, a threatening event, a threat that an event will occur, and that all the circumstances and all the facts have to be looked at. In this case, Mr. Soto had a gun. Mr. Kelleher did testify that he did threaten him, that he didn't want to go through with this, that he felt that he had no choice, that Soto talked about his drug suppliers and how they had to be satisfied.
Mr. Khan, you said your declarant testified that Soto threatened him. What was that testimony?
Excuse me?
You said your client testified that Soto threatened him. What was the threat?
He did not articulate what the threat was, so we have to look at it in context.
So he just said he threatened me.
He just said he threatened him. But in context, we know, and the jury could reasonably infer, which is what's important, that the drug trade was a lethal, dangerous trade. That was testified to by the...
Something he had been voluntarily involved with, at least as it related to marijuana at some point.
He and Soto were involved in small amounts of marijuana for about 6 years.
Was that less dangerous?
Well, there was no testimony about whether it was or was not less dangerous, but I think a reasonable jury could infer that selling small amounts of marijuana for personal use only would be different than selling large quantities of hard drugs.
Well, let me ask, I'm confused by one thing. You are suggesting that Judge Wilkins should have sua sponte given a duress instruction, right?
Yes.
And you were not trial counsel, correct?
It was not what?
You were not trial counsel.
No.
So did you file a motion for new trial based on ineffective assistance, claiming that trial counsel should have asked for that instruction?
I'm not claiming ineffective assistance and did not file the motion. I'm claiming miscarriage of justice.
So where I'm stuck then is, if it was okay, and I use those words in quotes, that the lawyer didn't ask for it, you're putting a burden on the judge to sua sponte, think about what defense counsel should have been thinking about strategy-wise. I'm having trouble getting there.
Exactly. I believe that the case law indicates that when there is sufficient evidence to satisfy a particular factual scenario, then the judge is obligated to give it, or at least the defendant can be prejudiced by its lack. I'm thinking in terms of lesser included offense instruction. So,
Why wouldn't counsel be ineffective for not asking for the instruction?
Well, that's one of the elements of miscarriage of justice. There were 4 elements under Freeman, whether there's overwhelming evidence of guilt, whether the nature of the error, could it have made a difference, and whether there's a tactical basis. And so this court can reasonably decide that there could be absolutely no tactical basis to fail to request an instruction that was the defendant's only defense.
So you want us to decide an ineffective assistance claim that hasn't been brought?
No, I'm not asking for that, Your Honor. I'm simply asking for a decision on substantial risk of miscarriage of justice from an unpreserved error.
And I put it more bluntly, actually. So I see that there was a strategy here. The counsel's argument was, my client was an active, willing participant in the marijuana, but he did not actively participate, he didn't knowingly, intentionally participate in the fentanyl or the cocaine. So his argument was, find me guilty of the first one, but find me not guilty of the other 2 because I lacked the requisite intent. But you're saying that the judge has said, and it would be, actually, but if I did do it, if I did have the intent, it was only because I'd been threatened. So I think that counsel made a choice.
Well, the question is whether or not that was a strategic choice and whether or not it was a reasonable choice. And given my client's testimony that he never wanted to engage in this in the first place, that he was in fear not only of himself and his family, that the evidence showed he never made any money on it, and it was corroborated by the fact that he was getting his driver's license canceled for failure to pay his insurance, that he had no weapons in his...
That supports counsel's defense that he didn't do it.
Excuse me?
That supports counsel's defense that he didn't do it.
That he never intended to. Not that he didn't engage in it. But, so counsel...
was there evidence that he was, except for constructive possession of the drugs, was there evidence that he actually sold fentanyl or cocaine?
Excuse me?
Was there evidence that he personally sold fentanyl and cocaine?
No, there was none. Basically, the position he was in was being the one who stored it and the one who packaged it. Now, I'd like to point out the cases of Contento Pachon and the Resor, the unpublished decision that in my brief, and those cases indicate that a defendant in those cases was distributing drugs, was on the distributing end because he and his family were under threat of death or serious bodily harm if he didn't engage in that. In this case, Soto was the one doing the distributing. My client was the one who was engaged in storing and packaging the drugs. But he was still doing it under duress. The duress...
Isn't the distinction between those cases and this case that there was a specific threat? I'm going to murder you and your family if you don't do this. And here, there is testimony that there was a threat. There's no testimony about what that threat was.
Again...
And testimony of your client's fear. But
again, I rely on Pearls. I rely on Pearls for the principle that the entire context has to be taken into consideration. He said he never wanted to do it. He said, he didn't believe he had a choice. That's at transcript 4136. He said he did not tell the police because he was in fear for his family. Also at 136, that they knew where he lived, that they could get to his family based on he didn't believe he had a choice based on previous threats from Soto when Soto first started getting heroin after he got out of jail. So I would suggest that Soto doesn't have to say, I'm going to kill you and your family if you don't do this, that he can understand
why was that the logical conclusion, why was that the logical inference, that there would be, that's the threat versus I'm going to inform on you to the police and you're going to get in trouble for doing this or whatever the other issue may be, and perhaps rationally, your client was fearful of the connection between someone having a gun and himself. But why isn't that speculation for the jury to make that jump between there were threats and the threats were of this particular bodily harm as well?
I think you can take it from my client's testimony that he didn't want to do it, that he felt he had no choice, that he felt his family was in danger. The threat is, again, as Pearl says, not the verbal threat, but the noun, like threatening rain. the threat of something happening, the threat of...
But it's something specific, right? It doesn't have to be something specific, not just a threat as a general matter.
It does, and I don't think that, well, I would say that a reasonable jury, given all the circumstances, could find that the threat was a threat of death or serious bodily harm. The Commonwealth's drug experts testified to it, that the drug trade was a violent, dangerous trade. This is something that Mr. Kelleher testified he got caught up in through no intention of his own, that Soto said he had to do it and he felt he had no choice. Soto had a gun. The fellow who delivered the drugs to his house had a gun. That Soto said, if we don't do this to satisfy our suppliers, we're in trouble. So I think you have to look at the entire case as a whole, not just a simple statement, I'll kill your family, but an indication by the defendant whose credibility this court should not, I respectfully submit, question, because it's really up to the jury to decide the credibility of...
Well, we have to look at the light in the most favorable to your client for this.
Yes, absolutely. In the light most favorable to the client, a reasonable jury could find that this was a threat of harm to his family.
We're on the time continuum, though, of these, what you are describing as threats, was Soto's incarceration. That seems to me like a break in the timeline where your client could have made a different choice, particularly where, as I understand it, at least at trial, he testified he had an uncle who was a criminal defense attorney. So help me with the timeline.
Okay. We don't have a particular date when Soto goes to jail, but he gets out of jail in August or September of 2017.
Was your client helping to sell cocaine and fentanyl before Soto went to jail?
No. The testimony was that he was only involved in small amounts of marijuana. Now, I want to make one point. In his confession, in his statement to the police, what the police testified, he said, is that there were greater and greater amounts. But that statement was taken in violation of DGM Batista. And the jury was absolutely qualified to disregard that statement as being in violation of DGM Batista. And so I would say that this court should not consider those facts in the...
Was that raised below?
Excuse me?
Was that raised below?
No, none of this was raised below.
So
This was all on miscarriage. Excuse me?
Can we consider it now?
Absolutely, because you're looking at the
risk.
You're looking at the case broadly. I respectfully submit under substantial risk of a miscarriage of justice. So no, there was no. He was not involved in any way until Soto got out of jail. And then at that point, it was only 2 months. This is not something that went on for years where you could say, well, why didn't you get out of it? You had all this time. It was only 2 months from the time that Soto got out of jail till the time they were arrested. So the jury could reasonably look at all these facts and say, he was under duress. He wasn't doing this intentionally, and that his state of mind was such that he was in fear. Now, in terms of being...
After you just asked this question, was there any evidence that your client saw Mr. Soto with a gun other than one time in either August or September of 2017?
Only one time.
Right after, within the same time frame that Mr. Soto was released from incarceration, is that right?
That fact actually would be transcript volume 4, page 128, that he saw Soto with a firearm. And this would have been after he got out of jail. So there's an awful lot of facts here that the jury reasonably could conclude, why Mr. Kelleher is saying, I was in fear for my family. Soho threatened me, Soho had a gun. They've heard from the drug experts that it's a violent trade. Frankly, I don't think that the jury needs a drug expert to understand from their common knowledge that the drug trade is a violent trade, the illegal drug trade. So...
Everyone, if I can ask this, then how is it the case that duress would apply to anyone who was involved in the drug trade, whoever was told, you have to do this?
Absolutely not. Each case turns on its own facts, and that's another indication, not a holding, but dicta in Pearls, that you really have to look at all the facts, and each case would turn on its own individual facts. Now, in my time remaining, I would just like to point out the four elements of prejudice under the substantial risk standard. Overwhelming evidence of guilt really doesn't apply here. My client concedes every fact of the Commonwealth's case. He concedes that he was packaging and selling drugs. So this is not a factor that should be weighed against the defendant. The nature of the error is serious. He was denuded of his only defense. This is basically the only defense he has. His attorney did argue intent in a broad sense, but this is what he testified to. And so that's why the error is a serious and not simply a peripheral error or a cumulative error. Could it have made a difference? Absolutely. This would have resulted in complete acquittal. And finally...
Your time has expired, so finish up your thought.
Okay. And, well, we've already covered that, which is whether or not there's a tactical basis. So if there are no further questions, I'll rely on my brief and thank the court for their time.
Thank you very much. Attorney McGee.
Good morning, Justices Blake, Hand, and Massing. May it please the court, no substantial risk of a miscarriage of justice was created by the judge not sua sponte instructing on duress, where the evidence of the defendant's guilt was overwhelming, of the defendant working in a joint venture with his friend to sell large amounts of drugs from his home in Norwood. Also, where the defense was fully...
Your brother counsel relies pretty heavily on Commonwealth versus Pearl, and you cited in your brief. Tell me why Pearl doesn't apply here or is not helpful to the defendant here.
It's right on point with the Commonwealth's case here, and I would suggest that Pearl actually there was a stronger case, because in Pearl there actually was a threat to the family and specifically to the daughter, but the court there found that the temporal aspect that we have in this case applied, and the defendant had moved to, the daughter had moved to California, and that the threat had occurred 4 months before the charged offense. Here, if there were any threats, they were in August or September of that year, and the execution of the search warrant was in November. Not only are the threats fairly amorphous here, but it's unclear who they were from, and also there was an opportunity there for the defendant to contact police or avail himself or extricate himself from the situation. But what the evidence bore out, specifically through the cross-examination of the defendant, was that he was very involved with this operation, that he was working and texting with Mr. Soto on a regular basis, was packaging and distributing the drugs from his house, from his bedroom, admittedly. And he was friends with Mr. Soto. When Mr. Soto went to prison, the first person that brought Mr. Soto home was the defendant. He had him live in his home. So the evidence bore out that these two were friends and were working cooperatively.
Is the case still pending, or is that resolved?
I'm not sure, Your Honor.
How do you respond to this, that he was denuded of a defense by the lack of a duress instruction?
I would suggest that the defendant's defense at trial was fully before the court. The defense was clear that it was about a lack of intent, and what was clear through the defendant's testimony and through the defense attorney's closing argument was that the defendant was trying to portray himself as a pawn, and that essentially, yes, he sold the marijuana for 5 years, that he felt comfortable with that business, but when it came to cocaine and fentanyl and heroin, that he felt like he was forced to do it, and he was a pawn in the relationship and lacked that requisite intent to possess and distribute the drugs in question.
I know the claim of ineffective assistance is not before us, but is arguing that I'm a pawn really a good defense to a trafficking charge?
I would suggest on the intent end, on a strategic end, it appeared that may have been the only defense in this case. The defendant was found with large amounts of narcotics in his home, admitted that they were his, immediately told the police they were his. It wasn't until the trial that he then testified that he was essentially a pawn, and that he lacked this intent, that people were delivering drugs to his house, and he felt as though he had no other choice. And that was what defense counsel relied upon and was hoping that a Norfolk County jury would also agree with.
Was there a charge conference in the case? I'm curious. I didn't see one in the record.
That I'm not sure of. I'd have to take a look at the docket on it, but I'm sure there was. It was a Superior Court case, yeah.
The way you just described it, wasn't that defense sort of just like duress light? Essentially, and defense need not be excellent to be strategic and for the to be an ordinary fallible attorney. And I think the facts were difficult here. He's possessed them, he's found with them, he's admitted to them, and what he was simply trying to portray was this individual from Hyde Park that was just leaving jail, that somehow made him feel scared and had people delivering drugs to the home that didn't speak English and carried weapons. We're somehow putting him in a place where he lacked the intent to do what he was doing, and that he was, as I said, a pawn. This young man from Norwood selling drugs for somebody from Hyde Park. Unless there are any further questions, I rest on my brief.
I don't see any others, so we will take the rest of the argument on your briefs. Counsel, very good job for both of you. Thank you very much. It's under advisement.
Thank you very much.
Apologize in advance if I mispronounce this, but our next case is Commonwealth versus SIFEDDINE Rogatti, docket 22P 1219. Good morning.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth. This matter is before the Court on the Commonwealth's interlocutory appeal from the partial allowance of the defendant's motion to suppress. I'd like to divide my argument into two main points today. The first point I'd like to address with Your Honors is the applicability of the Jordan decision to the facts of this case. And then I'd like to use the second portion of my time to discuss more specifically what was known about the car here based on the facts found by the judge and whether that amounted to probable cause for the warrantless seizure. So turning...
Will you jump in?
Yes.
I hope they're preliminary questions, but one of the issues you raise in your brief is that part of the reason they needed to seize the car was to preserve geolocation data, and defense counsel at page 35 of their brief says this was not raised below. So could you address that?
Yes. So I have a couple points to respond to that. During the second day of the motion hearing, the Commonwealth attempted to broach the matter of the subsequent search warrant that was procured. That is at approximately page 38 of volume 2. Defense counsel essentially objected and said, the issue here is the warrantless seizure, not the subsequent warrant, so why is this relevant? And the court essentially agreed with defense counsel, so there was no further discussion of the specifics of the warrant.
Is there any offer of proof?
So I would also submit that the Commonwealth's argument in its motion to reconsider would amount essentially to an offer of proof. But I think also it's important to note that if you read, now the Commonwealth questions this in its brief, but if you read the motion judge's ruling on the reconsideration motion at Record Appendix page 55, he essentially disclaims any reliance on the temporal nexus and says that his ruling was grounded entirely in the fact that, in his opinion, the facts known about the target vehicle did not amount to probable cause that it was the vehicle in question. So the motion judge's ruling, as he recounted it in the reconsideration motion, was strictly focused on, is this the car, not does the car. Now, and again, this was a warrantless seizure, not a search. So there was no search at the time the car was seized. So if this, I would submit that at minimum, based on the way the motion judge framed his ruling, if this court finds that there was probable cause to seize the car based on the fact that there was enough known about it that it could be found to be the car depicted on the surveillance footage, then the case should be remanded if this court feels that the Commonwealth has not raised the nexus to evidence issue for further consideration, because based on the motion judge's disclaiming of any reliance on the temporal gap and what might be found in the reconsideration motion, I would submit that he did not base his ruling on that, and that because defense counsel claimed that this was just about the seizure and not about the subsequent search, that the issue of, were there things in the car that could be searched was not directly the focal point of the suppression hearing.
So staying with the, I promise I'm going to let you get to your argument.
Okay.
Well, I shouldn't have promised that. You don't make a separate argument in your brief about the motion for reconsideration being denied. Is that right?
Well, the Commonwealth did file a notice of appeal from both. I suppose I just subsumed the whole argument in the context of the motion to suppress. We did specifically file a notice of appeal from both the denial of the original motion and the denial of the reconsideration. So the Commonwealth's assumption was that those were consolidated for purposes of appeal.
Now, I know that you didn't necessarily get to the geodata information below, and Justice Massing is the IT guru on the panel, I must say, but do you have to have the physical car in order to do the geolocation data search?
So I believe, I don't want to get too far afield.
I know.
Things not in the record.
That's
If
my
it's an
fault.
OnStar system, we can separately search OnStar.
Okay.
If there's an infotainment system, we can retrieve data from the specific infotainment system. I would also just note anecdotally that we also wanted to search the car for forensic evidence, for DNA to prove who was in the car.
Gunshot
We also wanted to search for gunshot residue. There were a number of things that we wanted to use the car to recreate the scenes on the surveillance footage. There were a number of things that were not gun that the Commonwealth wanted the car for that were much more durable. So to turn to the Jordan question, if you read the motion judge's original motion ruling, he essentially relies exclusively on Jordan. And the Commonwealth's position, and has been from the get-go, is that the description of the car in Jordan is somewhat a non sequitur based on how the decision comes down. The focal point of the Jordan decision is, number one, they did not identify the defendant as the renter of the car on the night the identified car was used. And two, this was not just a seizure, but an actual warrantless search specifically for a gun, and the court found that 2 days is enough time for, even assuming this defendant was operating the car on the night in question, 2 days was enough time for that individual to dispose of a gun, which is something that can be easily moved and transferred.
Right, because the description of the car in Jordan is ironclad, right? I mean, they've got the license plate. It's the exact, right? So there's no...
Much clearer than
which
in
is
this
weird,
case,
like,
without dispute.
So the SJC in a case where they know it's the same car still suppresses.
Yes, so which I think supports the Commonwealth's position, which is that the car's description was not the basis of the ruling that there was no probable cause. It was that they had not tied the operator 2 days later to the car on the night of the crime, and also the fact that this was solely about the seizure of a gun from the car, and that guns are easily moved, and one would have an incentive to move a gun if it was used in that car 2 days earlier, so there was no nexus. That was the basis of the Jordan ruling.
And in your case, the judge says there's reasonable suspicion to stop the car, right? And the question is whether it's probable cause. And so, and you rely on the fact that the defendant says, "I've had this car for 8 days," as that supplies the missing.
Mother.
Right.
The defendant admits during the stop that he and his mother, the car has been rented since December 27th, 2 days before the shooting, and that only he and his mother have operated the car.
And that information the Commonwealth gets before. That's what tips it over to probable cause in your view, would it?
Right, because he's
I
already
think
pulled over.
I think we certainly need that, because if this defendant did not have the car, I mean, we don't, admittedly, my brother is correct that we don't have any specific descriptors that made us think that this defendant was the individual. It was essentially just the car. So in that regard, I would actually say that the car descriptors themselves and where the car is found is really the thrust of what the Commonwealth is saying constitutes probable cause. The Commonwealth does believe that the defendant's operation of the car, and more specifically, the fact that it was rented in very short order before the shooting, is a relevant consideration. But the Commonwealth's position is we were looking not for a disposable gun, although that was something that was ultimately recovered as well, not just for a disposable gun, but for a variety of durable things. And that if there was probable cause to believe that this car, regardless of the driver, was the car that was observed on surveillance footage coming to and leaving from the scene both immediately before and after the shots are fired, then that is probable cause to search that car for location information, forensic evidence to identify the operators, and so on and so forth.
So in Jordan, on page 146, the SJC says, and I guess you both say Jordan is the key to your cases. So the SJC says, the judge concluded that 2 days were more than sufficient to remove the gun, and that's not here, but the absence of details about the car's rental weakened any link between the shooter and the defendants. And so,
Yes.
to Judge Massing's point, I guess my hypothetical is if Mr. Rogatti had said nothing about the rental, you're in a weaker position, right?
I think I would agree we're in a slightly weaker position.
Okay.
But again, I'm not to belabor the point. I mean, the Commonwealth emphasizes it in its brief. I think both the SJC in Gentile and this court earlier this year in Torres are very clear that this is not a matter of comparative analysis to other cases. Each case in the probable cause analysis has to be decided on its specific facts. And here, the Commonwealth's position is there was enough known in terms of specific facts that were known that narrowed down the realm of possible cars that could be the car that was stopped. That was sufficient for probable cause. We don't have to prove it was the car. We don't have to prove it was more likely than not the car.
But is that enough? Is the information, assuming that the judge found that the facts known to the police were those included in the draft bulletin and not necessarily those that could have been taken from the testimony at the motion to suppress, is that enough to establish probable cause given the variables that were included in the...
So, and again, in fairness to my brother, we're not disputing the motion. I'm not claiming the motion judge's findings are clearly erroneous. The judge made a credibility determination. The Commonwealth has to live with that. But the Commonwealth's position is that viewing this de novo, that there was sufficient. And I'd like to take your honors through the specific facts. So the bulletin stated that we had a newer model Chevrolet Malibu or Impala in dark cherry metallic paint. I will just note that Sergeant Quigley testified on the second day of the motion to suppress hearing that he had a 2017 Malibu and that the features on the suspect car were unquestionably newer features. So at a minimum, we're talking about a 2018 to 2020 Chevrolet Malibu or Impala. I would also note that Sergeant Quigley testified that prior to January 5th, they had been in contact with GM, and GM had told investigators that the color in question was available on the Malibu, the Tahoe, and the Suburban. Now, my brother points out that the judge's finding about the bulletin is suggests the judge discredited that fact. What I would argue to your honors is even if the officers subjectively believed, based on the judge's credibility findings, that they were looking for a Malibu or an Impala, objectively, there is no scenario based on that fact where they would have come across a Chevrolet Impala in that color, because GM said they don't make it in that color.
The draft bulletin, though, that was the first document, if you will. And as the judge says, the best evidence of in the moment, what the police knew. And I know that your brief suggests that the subsequent testimony is, these are my words, not yours, somewhat of an amplification of what was in the bulletin. But it's fair to say that the judge did not credit the officer's testimony about the description post-bulletin.
I agree with your honor that he discredited the officer's more specific testimony that they believed it was a 2020 Chevrolet Malibu as opposed to a newer model Malibu or Impala.
But even the things like what we presume is the transponder and the rims and the headlights. That wasn't in the draft bulletin.
So I do want to be clear, the motion judge's ruling also credited, independent of the bulletin, that there was a moonroof on the car, and I'll get to that in a second, and also that there was a white object. He refused to agree that it was a transponder. I think that's somewhat beside the point, but that there was a white object in a specific spot on the windshield. So we have, I'm sorry.
So you say this case is more like Brown, but I have to ask you because Brown says, or at least the description, this is at page 33, yellow Toyota station wagon with a roof rack, right? So I'm thinking about this black Cherry with a moon roof. But importantly, a dented side and a loose front license plate. We have no front license plate. Is that the same as a loose one?
So I'd like to talk about that, but I also want to be clear. I'm not saying this case is, the Commonwealth's position is this case is not like another case, and this court should not conduct a weighing of the facts in other cases versus this case. And I'm also not suggesting that this is an airtight, locked up, probable cause case. The Commonwealth acknowledged this is a close call. But I think that the specific facts we have to get, so I've already taught, we have a specific brand of car. We've narrowed it down to 2 models, though I've commented about the objective availability of the Impala in that color. And we have the specific color of which there could be many that the car is available in. The lack of a front license plate, I would argue, is stronger than the loose front license plate in Brown, because that unquestionably suggests that this is more than likely not a Massachusetts registered automobile. I think it's fair to say, and it's reasonable to assume, that the majority of cars operating in Massachusetts are Massachusetts registered cars.
The police testify to that, though?
The officer testified on cross-examination that there can be a Massachusetts car that has a front license plate. That is the green Massachusetts plate, which has been discontinued since 1987.
The green does not have a front.
A front is not required if you have a green Mass plate, but that plate hasn't been produced since 1987. I'm not suggesting there was testimony to that point, but I think people who live in Massachusetts, it's fairly common knowledge that you need 2 plates. If you go to the RMV and get a car, you need 2 plates for your car. And that has been the case for over 30 years in Massachusetts. So the Commonwealth knew that this was probably this car was a member of a relatively small subset of cars in Massachusetts, because I think it's fair to infer that the vast majority of cars operating in Massachusetts are Mass registered cars that have 2 license plates. So we have.
I've used up most of your time, and so I do want to let you get to your arguments. Do you have any objection?
My question's.
Do you?
And I guess if I could have a little leeway.
I will give you a little bit more time, as I will do to Mr. Wood.
Thank you. So the lack of a front license plate, in the Commonwealth's opinion, is a particularly distinguishable fact for this car, in addition to the fact that we know the color and the make, and whether you consider it objectively narrowed down to 1 or 2. You also have the moonroof, which, again, I dispute my brother's characterization of this as a generic characteristic that could have been available in all models. The Malibu and Impala are entry-level models of a relatively entry-level brand of car. The idea that any Malibu or Impala would come standard with a feature that is very commonly an add-on, like a moonroof or a sunroof, I would dispute. And I think that that's a common sense objective fact that doesn't need to be specifically testified to at a hearing. So we have you also have the white object in the mirror. Now, whether or not it's a transponder, there are obviously cars that have nothing on their front windshield, right? Even if you need you don't need a transponder in Massachusetts. All the signs when you pass over Easy Pass say, you don't have a transponder, we'll flash your license plate and bill you. So not every car has a transponder. Cars that do have a transponder can have them anywhere on the windshield. We had a specific object in a specific spot on the windshield that the judge admitted matched up in terms of color and location. So we have the object on the windshield, we have a moonroof, we have the absence of a front license plate, and we have the color and the information not specific to Malibu, but Malibu or Impala, newer model, most likely post-2017. The last thing I'd like to say is the Commonwealth does believe that the location where the car was found is relevant. 100% concede that this was a week later, that substantially weakens the value of the inference. But I think if you look at what we have here, we had a shooting that happened at 10 Bowden Street in Malden, very close to both Route 60 and Route 99, which can be easily taken to a highway. Instead of following either of those routes, this car takes a very specific path down a variety of side streets into a neighboring town, into a thickly settled neighborhood. And that is where the police have tracked it to Gledhill Avenue in Everett, but at the time that Sergeant Quigley and his partner observed this car. So I would suggest that that path of flight is indicative of somebody who knows the area and likely lives in the area. And so the fact that this car is then seen, this car with all these characteristics that match the things known by the police in the exact path of travel of the car, even though it's a week later, is a relevant consideration on the specific facts of this case based on what we know about where the car went after the shooting.
Remind me, where's the car found?
I'm sorry?
Where is the car found?
The car is found on the car drives by the officers on Gledhill Avenue in Everett, which was so the police had been collecting surveillance footage for essentially the entire week, and they had tracked the car through Malden on a specific path over Broadway into Everett, and they had tracked it. Now, it's not in the record, so I'm not going to get into where the defendant lived, but they had tracked it to this specific road and were in fact collecting surveillance footage from a house on Gledhill Avenue that depicted this car waiting for that footage to load onto a USB when the defendant's vehicle drove by them, and they said, that's the car. They followed it, they pulled it over. The defendant admits to being the operator, to have rented the car essentially a day and a half before the murder, and at that point the car is seized. So again, I'm not saying this is an airtight case. The Commonwealth recognizes that it's a close call, but there were a variety of things that narrowed down which car we're talking about. And the SJC and Guastucci recognized that probable cause is not a high bar. It's not more likely than not, it's not certainty. And here there was enough.
I think we're going to have to leave it there. So I gave you an additional 340. Mr. Wood, I've kept my eye on that for you as well. Thank you very much.
Good morning, Justices, and thank you. The judge in this case the motion judge found that the seizure of the automobile here was not supported by probable cause. We're asking this court to affirm for many of the reasons stated in the judge's decision, because what they knew about the crime at the time they made this stop was almost nothing, and the information that they did have, which largely related to the automobile, was of such a general nature as not to rise to the level of probable cause. Unlike a lot of car stop cases, in this case, there was nothing about the identification of the suspects themselves which added to the analysis. The testimony was that they did not know how many total people were involved in this shooting. They did not know their race. They did not know their gender. They had not a single physical descriptor that could be relied upon, whether it be hairstyle, height, or weight. They just knew.
You don't contest. They could pull him over and write the speeding ticket, right?
They had reasonable suspicions to pull him over for the traffic violation.
So then, when he acknowledges the timeline of the rental, Mr. Charles puts a lot of significance in that moment and sort of, I don't want to say that tips it, but I think that's essentially what he said. Do you agree, disagree, and why?
Completely disagree, because at the time that they seized that car, they don't have probable cause to believe this car was involved in the crime. So him saying, I had access to that car, plays a totally different role in this case than the statement or the lack of statement in Jordan, where they had more than probable cause that they were dealing with the same car because they had the registration. Here, and it should be noted, also, if there's not probable cause to believe this is the car involved in the shooting, then there's also not probable cause to believe that there's going to be important and usable digital information in that car, or fingerprints, or forensics, never mind getting involved in the gun. But getting back to what I was saying with regard to, what little amount of information that they knew, let's go to this question of the area where the car was found, because I don't feel that the area where this car was found or where it was ultimately stopped played a significant role in the probable cause analysis.
The judge does talk about I think he used the term exhaustive work that had been put into the videos, and it's just ironic that the car goes by speeding at the time that it does, but there is something to talk about in terms of the flight path.
Can I talk about it?
Sure.
So it is the case that this car was seen on the same street that the suspect vehicle from the video had been on almost a week before. But there was testimony at the time of the hearing that the car that was on Gledhill Road could have gone a week earlier, could have gone almost anywhere in the country in the 6 to 7 days between then and the time of the stop. Also, they have no information with regard to the registration of the car, which would have allowed them to tie this car to a particular neighborhood or a particular address. They also don't have any information that would have allowed them to tie it to a group of individuals that were tied to a particular geographical area. In fact, in this case, the only suspicion that they have that is far from well predicated, but independently of how well predicated it is, it's clear that at least Trooper Quigley believed that this was a foreign car, meaning a car registered in a foreign state. Whether that was a reasonable conclusion to reach, that was the conclusion they did reach. And between the two propositions...
Because of the license plate.
Just because of the license plate. So if we take that as a starting point, the two propositions, a Massachusetts driver driving a foreign automobile and a person from a foreign state driving a foreign automobile, those two propositions are at best in equipoise, and there's no evidence in the record or that was provided by the Commonwealth during this hearing that would have helped the judge resolve that question. In fact, for the very same reasons suggested in Jordan, there's actually less reason to believe that this car would have been on that street at that particular place a week later. Remember, a murder has happened. This car is allegedly involved in a murder. Allegedly, this person driving the car is a suspect in a murder case.
Here it was 6 days or 7 days.
Well, the
In
testimony...
Jordan, a couple of months?
What? In Jordan, it was 2 days.
It was 2 days.
It was 2 days in Jordan. It's
Okay.
6 days or 7 days here. The testimony was 6 days. I think when you do the math, it's actually a week. So in Jordan, they said there's no reason to believe that fruits or instrumentalities of a crime would be found 2 days after essentially a murder in that car because of the incentives that people would have to get rid of the evidence.
You would think so.
Yes, and that same incentive would exist in a person who knows that they've committed a murder in this car to avoid and not be driving around openly in that area. So the mere fact that it's on the same street that a car drove in a suspect vehicle and a video drove a week earlier is actually, if not completely meaningless, it's not really helpful in determining whether this is the same car.
Well, but, you know, if this was a black Toyota Camry, which I don't know how many I pass every day on my way in and out of work, black cherry metallic color seems not the garden variety, so it heightens it a bit.
It's not a black Camry, there's no question about that, and unfortunately, it's impossible to know how common a black cherry metallic Malibu is because there was no testimony with regard to that at the hearing.
But was there the evidence that Mr. Charles asked us to sort of infer that it was certainly after a certain period of time based on the trooper's own car ownership?
I think that the determination made by the motion judges that the most credible source of information that they knew about the car from the suspect vehicle from the video was contained in the bulletin. And the bulletin makes no reference to a 2020 Malibu. So if in fact someone testified to that at the hearing, it certainly wasn't the basis of the judge's opinion, and it was not ultimately credited by the judge as being...
I did not ask Mr. Charles this, but did the judge watch the video? Because we've
Yes.
ordered the video to be, I don't think we've received it yet. Can you, as an offer of proof, are we able to see more about the color of the car in the video as compared to the bulletin?
The bulletin says dark cherry metallic,
Will we
black
ever
cherry metallic.
actually see that?
The video is a compilation of several different video clips, and in some of them, it's impossible to tell the color. It just looks
Okay.
black and white. And then there's, I think, 1 or 2 portions of the video where it's clear that it's a purplish kind of hue. You can see.
And this is what Judge Boudreau saw at the motion hearing?
It was, yes, an exhibit at the motion hearing. So the mere fact that this car was stopped where they happened to be looking at that time is, in my opinion, if not probative at all, it's such a minor point that it cannot contribute significantly to the probable cause analysis.
Excuse me, I'd like to just get it nailed down what part of the description we can consider. So it seems to me Attorney Charles conceded that that we're looking for newer model Malibu or Impala, not 2020 Malibu, right?
Correct.
But he also said the judge did credit moonroof and white object, and you don't
Correct.
disagree with that. So we've got moonroof, white object, newer model, and we'll judge for ourselves what the color is.
And no front license plate.
Correct.
Okay.
And that is all from the bulletin. So,
And you're saying, and there's you disagree on the geographic nexus. I mean, what we have to figure out is this description like, a kid wearing a hoodie, or is this, a very specific with a person with a beard and one earring and,
Cherry black hoodie.
And a cherry black hoodie, yeah.
well, I think it's more like kid in a hoodie, and here's why particularly. Because if you look at, I know it's not a comparison, but if you do look at the other cases, the cases like Jordan where they had the registration, or the cases like Brown where they had a specific dent in the car, which was the result of a historical collision that is likely only to be on a single car. All of the descriptors, or there's another case where there's a very particular ornament hanging off of a rearview mirror. In all of these cases, the descriptors are asking them to look at a very small set of automobiles, maybe one, in at least the cases of the dent and the registration. There's probable cause to believe that there's a description of one automobile. What is offered here is a general category or a general set of cars that they're looking for. And we have no idea how many cars within Massachusetts or within the country fit this description. It could be thousands, it could be tens of thousands, it could be hundreds of thousands. But it's categorically different than the type of evidence that exists in Jordan, where they're asking about a specific description of a car, of a unique car, versus I'm looking for any Malibu or Impala that's of a newer model, and Attorney Charles says 2017 is what newer model means. I don't know what newer model means, but presumably there is a time range, and we just don't know how many cars between 2017 and 2022 or 21 fit this description. And so it's
fair, though, to assume that however many there are probably fewer of them in that particular location than there might be generally in this Commonwealth?
That would be, the first part of that is, it's presumably there's less in that area, but again, the question is, 7 days later, what's the importance of that area? And without some sort of story, you can imagine a scenario where they talk to witnesses and the witnesses say, oh, this crime was motivated by some sort of gang violence, and this is the beef that was going on, therefore connecting the car more likely to a certain neighborhood, or potentially having a suspect's name, which could then get us closer to a geographical region. The mere fact that the car drove from the murder scene on the night of the murder and was on Gled Hill Road, not knowing yet where the car ended up, not knowing where it was registered, not even having a suspect to tie it to that region, I'm not sure that that region is independently important. So yes, of course, if we reduce the geographical sort of space on which we're looking for this car, there's going to be less than the country as a whole. But the question becomes, why should we reduce it to that area? The police were not in a position to be able to have probable cause to think that the car would be in that area. In a world where, for example, that people use GPS, there's no reason to believe that a person who's from out of state would even necessarily not be able to use back roads to get where they were going. So, and with regard to another point on Justice Massing's point about the GPS, about the geolocation, not only if they don't have probable cause that this is the car, do they not have probable cause that they're going to find geolocation information, but there was no evidence at the hearing that there was geolocation information in this car.
Well, but he suggests that based on an objection, the judge ruled it irrelevant, so we could consider remanding it. You say it's waived?
I think it's waived, but I think the situation is worse than Attorney Charles makes it sound. Yes, there was an objection. The objection was talking about things that happened much farther post-stop, the search warrant that happens, a few days later, a week later. The officers in this case were asked to justify their stop on cross-examination and on direct examination in about 12 different ways, and none of them said, oh, as we were stopping the car, we noticed that there was an OnStar system and we wanted to be able to check that out. There was no evidence about that whatsoever. That certainly wasn't precluded, and you should look, I'm not going to belabor it, but look at the Commonwealth's response to the objection, because Attorney Brown actually states on the record what he wanted that information for, and about the search warrant execution has nothing to do with them wanting to get into digital evidence.
Did this judge make any findings about the, quote, distinctive shape of the fog lights?
Well, I think the judge's point on the specific nature of the fog lights, if I can sort of tell you my interpretation, is that the specific shape of the fog lights don't get them any further beyond the models that they think it is. Because if there is a distinctive shape of the fog light, that would already be entailed by saying that this is a Chevy Malibu or Impala. Because presumably what a newer model Chevy Impala or Malibu, because presumably what they're doing is they're using those specific features as a way of inferring that it is either a Malibu or an Impala. They don't get double credit for those features. They don't get to say, well, we thought it was a Malibu or an Impala, but we also thought it had fog lights that were like a Malibu or an Impala. And to the extent that these were specifically Malibu features, it's absolutely clear from the judge's findings that at the very least, if they are unique to a Malibu, the Commonwealth had no idea that they were unique to a Malibu or an Impala. Obviously, moonroof is not entailed by the make and model of the car, but to say that it is almost certainly a feature that doesn't come with the car, I think that's just guesswork. And
So you say that Brown or Jordan is the case that helps you the most. Attorney Charles suggests that this case doesn't fall neatly into Jordan or Brown. Do you agree with that?
I think that it has factual differences with Brown and Jordan, but I think our case is much stronger than both of those cases.
Oh.
Yeah, because remember, the fact that he says that when Mr. Rogatti is questioned after the stop, says, I've had the car for 8 days, that doesn't play the same role that it played in Jordan. In Jordan, remember, they knew, or they had at least probable cause to believe they were dealing with the same car. So the question was, in the Jordan case, was, are we going to be able to find the suspects or fruits or instrumentalities of the crime in that car? And therefore, the question of whether or not these people were the same people that had the car on the day of the murder became incredibly important. But where you don't know that you're dealing with the same car, the fact that he had access to that car on the day of the murder is far less relevant to the question of probable cause. The reason why Jordan's important, from my perspective, in part, is the proposition that is on the question of fruits and instrumentalities. Because in Jordan, they say 2 days later, there's no reason to believe that the fruits and instrumentalities of a crime this serious would still be in the car 2 days later, because of the incentives necessary and because of potentially that rental period creating a scenario in which a person had to get their stuff out of the car. Here, it's 6 to 7 days later. There's all the more reason to believe that there wouldn't be fruits or instrumentalities of the crime. And we're not in the place we were in Jordan, because in Jordan we had real reason to believe we were dealing with the very same car from the time of the shooting, which is not the case here.
Let me just check with the panel.
No. Although I do have one question. So because you got right into the argument, which was great, you didn't introduce yourself or co-counsel.
Oh,
Okay.
that was my fault.
I'm sorry. Joshua Wood for SIFEDDINE Rogatti and my co-counsel, Maura Berry.
Seem to recognize Attorney Berry there.
Yeah.
And I will say, the USB drive was hand-delivered. I just got a note from the clerk's office that they're uploading it for us, so we're all set on that. Counsel, both of you, excellent briefs, excellent arguments, really tough case. You were very helpful. Thank you both. Case has been deemed submitted.
Thank you.
Jeanette, is everyone here on the next? Okay. We'll take a break after DC. We're going to hear the next case, and then we're going to take about a 10 or 15-minute morning recess just for the other two cases that are in the courtroom. So our next case is the Department of Children and Families and Others versus Mother and Others. I will remind all counsel that, it looks like we're missing some people. I'm expecting 4 lawyers. Be more interesting out there. You never know.
I don't see how it could be.
Right, I know we have Attorney Salcido, Attorney Young, Attorney Orland, so we're waiting on Attorney Garove Wilson. And you've seen her this morning, Mr. Salcido? I have not. Okay, I trust our court officer that she has. They left? Is that the one that had the flat tire?
Yes.
All right, can I ask you to step back? I apologize, it was not clear if she's arrived. So, in terms of our timekeeper, we're going to move on to the next case. If you want to Oh, geez, look what I just touched my word.
I'm so sorry, Judge.
Big, oh.
No problem. It's okay.
All right, so let's try, maybe? CARLA Montero versus Shanti Acquisition LLC. Are the lawyers here for that case? All right, why don't we set up on that case? I just ripped my robe. Another one.
Nobody can see it.
I can see it.
Okay.
No, I know you weren't ready to be the next case, so take a moment to get
Thank you. I just
situated.
shoved it all back in the bag.
And Your Honor, just for the record reflects my business partner's name, Montero is here, but I will be arguing today, Attorney Shanti.
All right, if you,
And yes.
okay, so we don't have anything on the record because we're not on the record yet. So have a seat, and when it's your turn, I would ask you to restate that if you don't mind. I believe we're starting with Attorney Pruitt Barry, is that right?
That's correct, Your Honor.
Okay, when you're ready, counsel.
Thank you.
Another Barry.
That's funny.
Why don't you sit here, okay? And we can move down, but feel free to pass me stickies.
When you are ready, counsel, go ahead.
Thank you. Good morning. May it please the court. My name is Julie Pruitt Barry, and I'm here representing the appellant Shanti Acquisition LLC, and with me is my colleague Nicole Kokoza. What this case presents at its core is doubt, really, from the record before the court and the record that was established at the trial court. I won't belabor the elements of adverse possession, as I know the court is familiar with them. However, those elements requiring open, notorious, adverse, hostile, non-permissive possession of property for a continuous period of 20 years is critical to the ability of the courts to deprive one of their property rights and interests in favor of another who, by a set of facts and circumstances, is claiming that the property should be given to them.
Well, but when you say this is about doubt,
Yes.
right, isn't that really a question of how the judge weighed the evidence and credited or not the testimony of the witnesses?
I think that that is part of it, absolutely.
Right, and we have, as an appellate court, what can we do about that?
Well, I think that to the extent that there is doubt in the record that if infects the claim of adverse possession, that is an error by the
I
court.
guess I'm confused by the word doubt, because that's not a legal standard that I'm familiar with, so.
Then if I may expound a little, and I'm not meaning to speak colloquially. Under the standard, the burden of proving each element of adverse possession falls to the claimant, the adverse possession claimant, which here is Ms. Montero. the facts are not sufficient to demonstrate that all of those elements have been met. And if they haven't been met, or if there is a question as to whether they've been met, then the claimant has not proven their case.
I want to be just a little more specific, too, because this case was tried under Land Court Rule 14, right? So, which is, it's the abbreviated rule, it's the equivalent of Superior Court Rule 20. So we're on appellate review, we look at it as if it's a jury verdict. So we have to look, and which is like if there's anything anywhere in the evidence that supports it, then we can accept it.
I understand, and I'm trying to incorporate this argument around that Rule 14 verdict. The issue, I think there was an error by the court here, with all due respect.
Okay. So can I ask you on the facts? Throughout the briefs and throughout the trial even, there's reference to a shared driveway. Mm-hmm. Which driveway is that referring to, and who shares it?
So that driveway was shared between the owners of 476, 480 Harvard, which was the Poindexters, the predecessor in interest to Ms. Montero, a woman named Nellie Poindexter, and the owner of 48 Hansborough.
But they haven't been there since the house burned down in 1978.
They had, well, that's actually not correct, and that's where we have some doubt in this record. They actually were at the property on occasion, and there is evidence to show that even before the house burned down, that they were after the house burned down, that there were conversations between the Watts and Ms. Poindexter that were witnessed by her son, who testified that while Ms. Poindexter was gardening, and this is one of the elements that they've used to establish one of the facts that they've used to establish the element of adverse possession, was that she had used that property in part for a garden that she kept there for a few years. But there are also evidence from her son that while gardening there, she was talking to one or the other of members of the Watts family.
No, the record does not say that she's talking to a member of the Watts family. It says a neighbor, right? And if it does say, if you've got Watts family in the transcript, that would be helpful.
Yeah, I just want to get to the page, Your Honor. Thank you. If you go to the record appendix at 115, 116, which is the testimony of the daughter, Margaret Poindexter Evans. And beginning with the question 7, did you, after the house burned down, did you see anyone in 48 Hansborough at all? 48 Hansborough being the disputed lot.
Give me the page reference again, because there's actually a discrepancy between the PDF and the transcript.
Oh, I'm sorry. The index number is at the bottom of the page.
That's
the
fine.
So it would be the transcript page 1110.
Okay.
The RA is RAIA-116.
It's 118.
Okay, so you're.
Thank you.
Did you see anyone? Okay, so we're on. So go ahead. I'm with you now.
Right, and she said, and the question was, did you see anyone at 48 Hansborough after it burned down? And Ms. Evans responded, I would sometimes see somebody on the porch there.
Well, but it burned down. How can there be on the porch if it's burned down?
And if I could direct you to, well, in this same area, if you go down to question 18, and the response at question 21, did you ever see anyone come onto 48 Hansborough Street? And the answer at line 21 is, only when my mother had a garden behind her fence, someone would come out there when she was out there gardening, and she had some men. She would sometimes give them something from the garden. And it goes on to the next page, 117, with the question, would these just be neighbors, or would it be that, there's something missing there, would come over to her in her garden? Do you remember? Answer at page 117, line 5, it was the person who lived there, but I don't know him.
Okay.
Which suggests in every way you look at it permission, because the person who lived there knew that Ms. Poindexter Nellie Poindexter to the extent she was using their property for a garden, and that's another disputed area here because there isn't any evidence of exclusive, notorious, hostile possession over the entirety of 48 Hansborough Street.
To Justice Massik's point, though, what year did the house burn down?
I believe in the 70s.
Okay, so
I
this
believe in
conversation, if it were taking place while the house was still in place, was necessarily more than 20 years prior to the claim of adverse possession?
The garden, she had the garden there from 96 to 2000
Right, but
something.
if I'm understanding your point correctly, it was that the proof that the Watts family was there was this conversation that's being described at Record Appendix 1, 118, 119.
That was in response specifically to the question of the issue of her gardening while there was someone at the
My apologies,
property.
I'm sorry to interrupt.
But that was, she says that she doesn't know, and so, but she remembers her talking to her while she had the garden there, and the garden was there from 96 to 2000, and I believe it doesn't say they were on the porch. It doesn't say they were on the porch. Did you see anyone come onto 48 Hansborough Street is what the question is at line 18, page 116. And the answer is, only when my mother had a garden behind the fence, someone would come out there when she was gardening. Doesn't say they were on the porch. Doesn't say there was a structure there. It says they would come out there when she was gardening. Just because the structure burned down didn't dispossess them of their ownership of that lot.
Did the judge have to credit that testimony? Did the judge have to credit that testimony?
I'm sorry, I still didn't hear you.
Did the judge have to credit the testimony?
I think the judge needed to credit that testimony as adverse to the claim that this was somehow some sort of notorious possession because there was the owner of the property there, as testified to by Nellie Poindexter's daughter, who came out and talked to her. I don't know him. He was the person who lived past
The judge
tense.
didn't credit that.
He should have credited that.
Right, but if he didn't, is there other evidence to suggest that the Watts family had been on the property?
If you'll give me a minute, I can find that. And just to your point, and even if there was no other evidence of any other person there from the Watts family, how many times does it take for someone to sit outside and see someone working on it? But there still is no evidence, and this is the other evidence. It's not clear. Even if the Watts family came out there once, even if they didn't come out there every time that Ms. Poindexter was gardening, even if they didn't say anything every time someone used the shared driveway, which the Poindexters testified the fence was purposely not erected in a way to block the driveway. They disclaimed in their testimony ownership of 48 Hansborough Street. They never said that they owned it or that they were adversely occupying it. In fact, every effort was made to keep that driveway open, and there's evidence of people walking through the yards, through the driveway. The fence was not maintained.
So what is it, they walked, is there evidence, I mean, it seems like isn't the evidence there's a fence that surrounds the property, except that it's got a gate?
It does, yes, it doesn't surround it entirely, and it had a gate which is never locked during the day.
Right.
There's evidence that it may have been locked at night, and then there is also evidence, undisputed, that the gate was broken a long time ago.
So for people to cross the property, there has to be an opening on the other side as well. Is there evidence that people are actually, there's a...
I don't think the fence enclosed the property. It's not a boundary fence.
So there is an opening in the fence on the other side?
That's my understanding, yes.
And where is that in the transcript? It just took a view, right?
Let me just find the appendix, the site in the appendix, Your Honor.
I saw there was a cross-examination, impeachment with a deposition about you saw some people crossing through there. She says, yes, I saw some people on the property, and then she said it was my kids' guests playing basketball.
So that's what she saw. But we don't know what she didn't see, and we don't know how many of there was no identification of those individuals. It was in her interest to say that the people crossing through the yard were her sons and friends of her sons. But friends of her sons aren't in her family, and there's no evidence to suggest that, and this goes to the exclusivity, that she either acted to exclude anyone other than friends of her son, or that she acted in any way to exclude anyone else from that property. In fact, the evidence, the issues of adverse possession, and the evidence that goes towards showing it that the plaintiff, that the appellee's proffer increased around the time that Shanti Development purchased the property, and that's when we started to see the parties, and we saw the two parties in the driveway, and these types of things, and the idea that the use by Ms. Montero, that she has proven exclusivity because when Shanti tried to remove their vehicles from being parked there, that they filed this action, the underlying action.
I don't know if I got the answer to my original question, which was, who did they share who is the driveway shared with? Who else used the driveway besides occupants, besides the Monteros and the Poindexters?
Well, the evidence is that it's between the two properties, the Montero, well, shorthanding it as Montero, although we obviously object to the use of Montero to describe all these things because Ms. Montero didn't own the property till 2010. So there's a tacking question here which leads to the doubt issue.
Well,
the driveway was shared between 476 and 480, but there's also evidence that others used and parked at the driveway.
There's evidence that others used the driveway.
Oh, and 48 Hansborough, sorry.
So,
Between 476, 480 Harvard, and 488 Hansborough are the people, the properties that use the driveway.
So people from the burnt-down house still parked there?
Yes, it's my understanding that that driveway was open to anyone who needed to park there.
Weren't there signs that said no trespassing, do not?
There were no trespassing signs on the fence, however, they were in disrepair. I believe some of them have fallen down, and again, it's hard to maintain a no trespassing claim with a broken gate and a fence that doesn't operate to exclude everyone from the premises, which is what's...
This is a housekeeping matter. I didn't see the complaint in the record.
I think it may have been attached to...
Perhaps with consent of your sister council, you could file that this afternoon.
Absolutely, although I thought it might have been attached to my sister council's brief, but I'm incorrect about that. We will endeavor to do that this afternoon, absolutely, Your Honor. Apologies, I've lost my place. So the gate that is located on the Hansborough Street side, there's testimony at A150 in the record that the gate on the Hansborough Street side always remained open during the day for the entire time that the Poindexters lived at 480 Harvard Street. And
your time has expired. Let me just check with the panel. Seeing no further questions, counsel, we're going to have to ask you to take the rest of your arguments on your brief. Thank you.
May I just mention one other thing at line 150, Your Honor, which was it was never your intention to keep the record owner of 48 Hansborough Street from accessing their lot. No, sir, we weren't aware of any record owner, but if there was, they could have come to us. We never intended to keep any owner off the property, and that's at the record appendix at 150.
Thank you, counsel.
Thank you.
Now, if you could tell us your name.
Good morning, Attorney Cheryl Fanari. The list cites my business partner, Mordetta DeRizier. My name is S-H-E-R-Y-L, last name Fanari, F-U-R-N-A-R-I.
And you have filed that with the court officer?
Yes.
Okay, you may proceed.
Absolutely. What we have, the possible reason that there might be some questions in the case is that Mr. Shanti didn't present much evidence at trial. The evidence presented was the witnesses that I had presented on behalf of my client, Ms. Montero, and family members from the Poindexter family. I do believe that the judge looked at all of the facts, and even if there was possibly two plausible stories, I would ask that still if the judge could have gone one way or the other. There's enough evidence that was presented at trial to be able to cite that finding that it was erroneously found is just far from what really happened here. We have a situation where...
But we don't really have findings here, right? As to Justice Massing's point earlier, this is a Rule 14 trial. We have a lengthy special verdict form, and what are we supposed to do about the findings? There aren't any.
Well, Your Honor, what I would merely say in terms of the judge's decision to support adverse possession found by my client. And in the record and in the transcript, he actually spent about 45 minutes going into each element, why he found through the case law and supporting facts to make his decision under Rule 14. When it came to...
So does the standard of review change under Rule 14? How do we assess something as being clearly erroneous or not under the special rule?
Well, I do understand that there is a distinction and difference when you come to the appellate court under a Rule 14 trial. When you're reviewing that, you are not re-reviewing the facts themselves. The facts are only to be reviewed by the judge, and he makes those determinations. As you had stated earlier, as though as a jury had heard them and made a verdict. And I would simply state that under Commonwealth versus Carr, when there's a plausible scenario, when you look at all of the facts, if it's plausible, then it was an appropriate decision. There's nothing here to suggest that there was facts that were presented to the judge during that hearing that would find otherwise. What I had here, when I was even going through the discovery, when I was listening to the deposition, when you're a first-year law school student in property class and you're looking for the easy adverse possession question, and the witness says, yeah, I mowed the lawn a couple times a week, I shoveled the snow, I took care of the weeds, we put a garden in the yard, we planted a tree, we took down the tree, we got a permit to put a fence. There was a fence put up around this entire yard because there was a shooting. And so the owner said, you know what, let me fence the entire property in. There is a fence, there is 2 different fences that go around the entire property. The opening is that driveway. And it wasn't shared by anyone else, and no evidence was presented it was shared. The only persons that used that cement portion through that driveway was the Poindexter family members and also Miss Montero. And the pictures and items about use from my client, I know there was a statement saying that the use was increased upon finding this issue. That's not the case. During discovery, we presented pictures and evidence of use of that prior to finding out that Shanti even had an interest in this property. The reality is we've had use of this.
We're not looking at the discovery, right? We're looking at what Judge Spicer had before him.
Absolutely.
So what you just referenced, was that before the trial court judge?
Yes, we presented those.
Where is that in the record?
So there was, the pictures were submitted as evidence, as exhibits, agreed upon exhibits in the exhibit book.
I don't think we have those.
I was merely addressing the comment or point that there was no evidence presented of any use by my client prior to trial. However, I can move forward. What the judge did here is testimony from the Poindexter family that they used this land in such a way that they mowed it, and it wasn't just intermittent or limited or sometimes, no, it was regularly maintained for each different season, whether it was the raking, the snow, the mowing, the planting of bushes, the planting of gardens. It was used like a true owner would use this land. And I think the biggest piece, though, is that the requirement of exclusivity does not mean it doesn't have to be like the sandlot, right? We don't have to prevent every single person and have an iron gate up and, and guards at door. No, you exclusively use it like a true owner would. And that means having a fence with no trespass signs. That means taking care of the land and having barbecues and family events and parties on there. It was a situation where there was a surprise that anyone else owned the lot. When you walk into this lot at the site view and you turn to one side and you continue and go around the entire property, as you spin around, all you see is a backyard and a fence. And the fence from the 1970s, still present and still there. It's clearly something that has been used for more than the statutory period of time. And conveniently, because we had only 2 owners, tacking is seamless here. We had a situation where obviously Miss Poindexter wasn't here to testify for us, but her children, who she raised in that property, were well in their 80s and retired, testified to all of their maintenance and use of that property. And it wasn't just a mere mowing, right? I think what the appellant wants to do is set a new rule, set a harsher standard for what it means to be able to exclusively and actually and open notoriously use it. They want to make a strong rule, and none of the cases suggest that the only way to own property is if you have a garden, a strong gate, or no one ever can come into the property, or you have to actually build like a garden house on the property. That's not the cases here.
But what about the I guess it's the deposition testimony that's used on cross, where Ms. Montero answers, so people would cross through the yard if the fence was open? So is there evidence people were crossing through the yard?
I believe that there is a bus stop. She further goes on to testify in the same line of questioning that there was a bus stop. So she believed kids were trying to cut through the corner as they were walking to school and cutting through her lawn. But what I would say is that in the cases that if someone were to, every occasional trespasser or a person that simply steps on your lawn does not mean exclusivity is now not met. You can have someone who just hops on a front lawn even without a fence, or someone who tries to cut through your yard to go into the bus stop. It wasn't one person. There wasn't like a footpath made or consistent regular use by someone, but on occasion there would be persons who would cut through to try to get to the bus stop. Yes, that is the deposition testimony. But I would say that is not sufficient based upon the cases. When we look at exclusive, it means I use it as a true owner would, not just that I've excluded every single person successfully.
What about the testimony that we never intended to keep the property owner off?
I do believe that was one of the older siblings. I believe that, when they were the questionings and the line of questionings and deposition is that, was it your intent? I think when we look at, it's not just the intent, but it's also what occurred, right? It's not just your thought process at the time. I don't think they meant to hurt the Watts family, but the practicality is, did they actually use it to their own exclusive selves? Did they use the land and all the different elements they did? Whether they wanted to hurt the Watts family or steal from the Watts family, clearly that wasn't their purpose, was to steal from the Watts family. But that is exactly what they ended up doing, because they used the land as their own while the Watts family had left after the fire.
One more question.
Sure.
Along these lines. There's evidence that the prior owner, Poindexter, applied for and received title to 476 Harvard after that house burned down?
Yes.
Why didn't she do the same thing for 48 Hansborough?
I would be having to guess for you. I know that there was one house that burned down.
It sounds like it was the same circumstances, right?
I believe the city had come forward and offered to the family to purchase the land. So the way 48 is here, and then 476, and then 80. So it's a curve. It's a curved. And so when this house burned down, and there was problems in the neighborhood already accumulating and starting, the city said, do you guys want that? Do you want the next part of the sliver of your backyard? And so they said, sure. I think they bought it for nominal money. It wasn't much money at the time. And then the second house had burned down. So they had then the next piece, but I don't know. I would be guessing, Your Honor, as to why the city did not present that. What I do know is when they applied for the permit for the fence went around all three properties, 46, 48 Hansborough, and the 48 Harvard Street.
So the appellants buy a property that's on the in the it's in the registry of deeds described as 48 Hansborough, and it's got boundaries and stuff like that, and they pay what, $220 or something for it?
Yes.
And then they learned that they bought nothing?
In terms of the appellant?
Yeah.
So what I believed happened, this was in an estate sale. He's a regular, consistent developer, and he was purchasing land that was probably very low because it was at an estate sale, and he bought it from the estate of the Watts. The Watts hadn't used it, but found out they had an inheritance and were merely cashing a check from an inheritance from an old property, is what had occurred. And at the time, Mr. Shanti wanted to go forward to develop the land, applied for a permit, and tried to even start construction in the middle of this case, and has taken out a $1.3 million loan to construct the land itself. And so that is still pending as well. However, if you appeared at the land, the fence does surround the entire lot. And I know there's a lot of discussion about improper description, but I just want to be very clear that all the improper description is if you're trying to determine that I've only adversed part of your land, right? What land, because you can only give a piece of adverse possession, either the entire amount, or if you're looking for a prescriptive easement, I need to know, was it a footpath, is it a driveway? All of those cases are looking for what part of 48 Hansborough Street was actually used. And so at all times in the complaint and at trial, the description was this 48 Hansborough, which is the land encased by that fence. And I'll also mention at trial, there was no evidence presented that only partial 48 Hansborough was used by either side. It was just a discussion that this part of the yard basically extends. It just looks like a bigger backyard, and that in the back end of 48 is where the garden was, and the entire yard, 46 and 48, were both mowed at the same time, taken care of at the same time. It's all one area to be able to take care of. If you were to walk on the land, it's not like it's pavement and grass. It's just a big grass area.
I know you still have some additional time. It doesn't appear that the panel has any questions. We're happy to take the rest of your argument on your brief, or you may use your time as you see fit.
Absolutely. What I would just like to say, or what I was beginning to say earlier, is that when I was listening to the evidence on this case, I've never heard when I heard all the discovery coming out, I thought, we're going to settle this. This is a situation where I have someone testifying to how they mowed the lawn, how they shoveled the snow, how they planted gardens, how they planted trees, they took the weeds, they added a fence, they made sure the land was protected, and they had all their parties. This is a situation where I couldn't have had a better fact pattern on a law school exam. I literally had the entire family tell me how for 40 years and growing up that they were taking care of the land, and even when they moved out of their mother's home, they still came back and continued to take care of the land. And then Carla did as well. This is a situation where you really just have a big backyard that was maintained and thought of as one unit. And my client literally, there was no way for her to even have an understanding that there was an actual separate lot, that she was not being sold. Because even when Miss Nellie Poindexter's estate sold it to my client, it was advertised on the MLS as an entire backyard and all of hers. It's because it's so obvious.
Would you say the evidence at trial supports the conclusion that after the Watts' house burned down, they're no longer heard from?
I'm sorry, can you say that again?
That after the Watts' property burns down, they're no longer heard from?
Correct.
Notwithstanding the talking to the neighbors?
Notwithstanding possible conversations that might have been remembered, and again, these are testimonies by the elderly folks that might have heard them when they were living in the property in their 30s and 40s, and they are now in their 80s. And so we couldn't necessarily track down the Watts family themselves, or they weren't presented at trial by anyone. But this situation, literally when the houses were burned down, the property was creating issues. In fact, there was a murder in the backyard because it was an empty lot that persons in that neighborhood were using, and that was part of the reason why they wanted to get the fence. And they didn't want, because they wanted.
Is that in the trial? The
I believe it's in the deposition transcript,
Okay, so we
and
don't have that
I don't have it on hand. I could find it, where they just talk about one of the reasons why Mom wanted to get this fence.
We can't consider that. We only can consider the stuff that's in the trial.
But I would just simply say is that this land was used like a true owner would. It wasn't just mere gardening. It wasn't just mere mowing. It was literally, I'm going to put a fence around my yard. I'm going to maintain it on a regular basis per the season. And yes, Carla might not have had all the receipts from every time she mowed her own lawn, but she regularly had landscapers and things of that nature. This was used like a true owner would in the fashion it was. And I would just request that you find that no error was found by the decision and uphold that decision.
Thank you very much. The case is submitted. We're going to take a 10-minute or so morning recess. When we come back, we'll hear the last two cases on the list. Everyone's here now? Excellent.
All right. back in session. Please be seated.
So we're pretty impressed that somebody changed a tire and still came to oral argument. You're a better person than me. All right, so we've gone a little out of order. So now we're going to hear Department of Children and Families and Others versus Mother and Others, which is 23P0182. As I understand it, I want to make sure I'm right. Mother's Counsel, 10 minutes. Father's Counsel, 5 minutes. DCF, 8 minutes. Children, 7 minutes. And reminder to everyone that this is a partially impounded case, so please don't use anybody's names. With that said, counsel, when you're ready.
Thank you. Good morning. I'm Robert Young, and I represent the mother. This case, from the mother's perspective, involves a sequence of errors that deprived her of her right to counsel. That sequence of errors is not harmless, and it requires that the decrees be vacated. It began with the trial judge's abuse of discretion in the handling of counsel's motion to withdraw that was filed before the start of trial. That was problematic for a couple of reasons. First was the judge denied it without a hearing, and in denying it without a hearing, still issued an order.
But denied without prejudice to re-raising for a hearing at a later date and included certain options for the mother. Is that correct?
Yeah, a list of choices, an a la carte list I've referred to it as, which did not include the most important choice, which would have been new counsel for her. She didn't ask to represent herself in the motion that trial counsel filed. Trial counsel said, there's been an irretrievable breakdown, and mother has discharged me. Under Olivia, that's good cause certainly for a hearing on the motion, in order to hear a little bit more about where everybody stood, to balance the competing interests, which are significant.
That was the sixth counsel, right?
Yes.
I mean, are you entitled to ad infinitum?
No, it's not endless. But as I noted in my brief, I think in footnote 7, I tried to tally up the sequence of how we got to 6 attorneys. And it's certainly not clear in the record that mother fired all of them. The first attorney served at her side for about 20 months and withdrew when the first trial went off the rails. I think that was around the time of the pandemic, if I recall correctly. 2 or 3 subsequent attorneys withdrew almost immediately upon being appointed because they had conflicts. Okay, so out in far western Mass, that panel, there are regularly conflicts that arise. Then, as mothers...
The judge cited the lack of counsel as another reason for denying.
But the problem with that is not the mother's responsibility.
Right.
It's the court's responsibility, and it's a problem, and it's real. But that's why, rather than just saying, sorry, we can't provide you an attorney, the court needed to explore the issue a little further. Maybe if the court had held a hearing and actually balanced the competing interests, there would have been something more in the record that justified.
What number attorney was that, though, in the continuum?
Which attorney?
Right when the judge said that there's a problem through CAFL and CPCS getting
It was this final one.
It was this one,
It's
okay.
typed, the only thing we get from the motion is sorry, you filed this 3 weeks before trial, but I have no time to hear this before the trial date, with no explanation. There is a constitutional crisis of counsel, and you've had your fill, basically. I'm paraphrasing, but that's written on the order. The court restates that on the day of trial, after getting mothers acquiescing to self-representation, notes again this idea of constitutional crisis. You've had 6 attorneys and so forth. I also make the argument that one of the problems with how she handled this motion is it implies that mother is waiving counsel by virtue of conduct. The Raisa case is the one I point to. That's not clear here. There's a facial allegation of irretrievable breakdown. The judge doesn't explore that, and we end up with that setting the stage then for...
But if she's firing lawyers because of her mental health issues, is that tantamount to conduct under RESA?
No. And if there's an issue, the mental health, that gets me to down the road with the further errors, that this judge didn't do anything to probe the mother's competency to waive counsel. The issue of mental health was live and substantial in the record. And in fact, just briefly stepping backwards, the sequence of discharge of counsel, I think if you compare in the record, her increasing mental health struggles coincided with the breakdowns with the more recent attorneys, okay? This judge was not the judge for the entirety of the case. She was assigned to do the trial. She did the final pretrial. In fact, in that final pretrial, she heard that there had been delays for a number of reasons: change of judges, the pandemic, change of counsel. Mother objected in writing to the judge's a la carte limitations of her choices, saying that as a consequence of not being appointed new counsel, she would go with the next best option, which was
Standby.
Pro se with standby counsel, with the attorney that there's an allegation there's an irretrievable breakdown. But she did not wholeheartedly seek to represent herself pro se. And the judge even heard those answers the first day of trial in the colloquy, where mother sounds a note of resignation. This is what it's come down to. I've had 6 reps that have just not worked out for their own reasoning. We're at trial now, and I feel like this is where it might be best for me. The judge does not follow up on that idea. Why might it be best for you? In the colloquy itself, after mother is sworn, going through some it's about as minimal a colloquy as I've observed, gets to the question about, are you doing this of your own free will? And the mother says, without another option, yes. Now, to me, that screams equivocal, some type of equivocation, calls for some type of follow-up probing. And instead, the judge immediately, without skipping a beat, pivots right after that answer, if you look in the transcript, page 28, to orally finding that the mother knowingly, willingly, and intelligently waived counsel. Notable, the words voluntary and unequivocal are skipped. Not that that decides the case, but it's problematic. And then when trial counsel, standby counsel, notes for the judge that there is a concern about mother's mental health, her functioning, that the department is going to put on a case about that. And then also father's counsel objects on a similar basis. This judge says, I have to presume the mother is competent. But in the face of those concerns raised by counsel, the judge needed to do more. She needed to probe that a little bit. She asks mother in the colloquy, one of about 6 of the 6 questions, do you have any mental health diagnosis? Now, the mother is sworn testimony here, and the colloquy says, no. Well, the trial proceeds, and there's quite a bit of evidence, even from the mother's own mouth, of delusional compulsions that she's experiencing. What does the judge do with that? The judge does not put the brakes on in the middle of trial, which I submitted a Rule 16 letter of adoption of Igor, most recent one, and I think those 2 cases, adoption of Brianna and adoption of Igor, bracket what was the sort of the discretionary range for the judge here and what should have happened. But in Igor, that judge, in the middle of trial, conducted a third colloquy. And because it's an unpublished decision, we don't have all the facts, but obviously there was something that gave that judge pause. Instead, this judge hears mother's delusional testimony, and trial counsel, standby counsel, renews her motion for a competency evaluation, which I know mother actually was willing to participate in. And the judge says there's absolutely nothing about mother that leads this court to believe she's incompetent. And again, it's the incompetence to waive counsel, not the incompetence to represent herself. And that's an important distinction. That my concern in reading how this judge handled this is that she conflates the two. I can see my time is about up.
Let me just check to see if the panel has additional questions. I don't see any, counsel, so we'll have to take the rest of your argument on your brief. Thank you so much. Attorney Orland on behalf of the father.
I'm Attorney Orland here, representing father. I will say that if I use the term daughter, I'm referring to daughter number 2.
Okay, right. He's only the father of that child.
Correct.
Okay.
The father, as counsel said, also moved with regard to mother's competency. He filed.
Quick, how is he harmed, even if mother's not competent to represent herself? How is the father harmed by that?
Harmed by her cross-examination of him on the last day of trial. If you look at the transcript from the last day of trial, there was testimony about her delusional behavior, her shouting 333 and words to that effect. And also, if you look at the content of her cross-examination of him, there's also the possibility that he would be painted with the broad brush that mother was by the judge hearing the case. I also would like to talk about the admission of acquittal evidence regarding child sexual abuse charges. Father was charged with multiple counts of abusing a child sexually. He was later found not guilty on all charges, but in evidence, there were multiple references to father as a sex offender. And sex offender is a term of art, both legally and psychologically.
But no, the judge doesn't cite that as a reason for finding the father unfit or terminating him, right? His rights, right?
Father, in the...
You just mentioned it in the findings of fact, but that, of all when she lists the reasoning for her ultimate decision, she doesn't mention sex offender at all.
Well, she does say that she doesn't credit him with saying that he did not commit a sexual offense. The records submitted by the department refer to him as being a danger to
yes,
both.
But that being the case, doesn't the judge know how to properly instruct herself and to take it only as context, as she says, and not as part of her reasoning?
Well, she did refer to broadly to his criminal, both parents' criminal history, and that can be taken to include both, include the sexual offense
But
charges
counsel,
as
front
well.
and center to the whole case was the domestic violence issue, which was sort of the focal point of all of the discussion of the criminal activity, correct?
It was certainly a large part of it, but the reference to father as a sex offender was in multiple, papers listed. I'm so sorry.
No need.
But he was referred to as a sex offender multiple times. And that certainly was prejudicial to him. And he, with regard to the references to him as a sex offender, trial counsel preserved that issue, as well as preserving the issue of whether there should have been a bifurcation, primarily due to mother's mental capacities. So there is also the psychosexual evaluation that was submitted in evidence, and the testimony of Dr. Guidry, who performed that evaluation. And she found that although he had a history of criminal convictions beginning when he was 18, his record was entirely non-sexual. There was no pattern of sexual deviancy, no evidence that he met the diagnosis for pedophilia. And she also noted that criminal recidivism declines once someone reaches the age of 40, and he was at that age. So with both her report and her testimony and the acquittal, that evidence should not have been admitted. And it was, because he preserved the error, it was prejudicial error.
I'm kind of intrigued by your argument about the business records. I mean, the statute does say that they have to be made before the commencement of the civil or criminal proceeding, but I'm wondering how that works in a care and protection case, because, right, often the petition is filed, years and years before and there's lots of activity, and children are taken. DCF gets custody. They're reunited with their parents. They go back and forth, and so is what is implied from your argument is that any occurrences that happen after the care and petition is filed can't be used in the case. Is that really how it works?
Well, there was a request that the evidence be redacted, and trial counsel.
But if anything if a care and protection is filed in 2017, then any police reports after that are inadmissible?
Well, it would seem that the judge at one point said she would review redacted evidence, but and trial counsel, this is not on the record, so I'm sorry, told me that he did go in and redact. And she could have used those versions of the documents, of the police reports.
What was, okay. Well, I think we'll have to leave it at that.
Thank you very much.
Thank you.
Attorney Salcido?
May it please the court, Richard Salcedo for the Department of Children and Families, and I'm joined today by counsel for the children, and we'll be splitting our time as we indicated earlier. The department is asking this court to affirm the trial court's decision finding mother and father unfit and terminating their parental rights. In reaching its determination, the court entered 243 detailed findings of fact, none of which are challenged on appeal. And taken together, those findings clearly and convincingly support the trial court's conclusions.
Could we jump to the issue of competency to waive counsel? And in light of the circumstances that the judge was facing on the first day of trial, how do we credit the determination that there was no basis for conducting further inquiry or for conducting an evaluation under, say, Halty-Wanger, but for conducting a further evaluation?
I think the trial judge at the outset and during the colloquy had little reason to doubt mother's competency at the time. At the outset, that issue about mother's mental health was raised, but the court noted at that time that there was little reason to believe that the mother did not understand the proceedings or the nature of the proceedings. The court noted that mother...
Isn't that's competency to appear as opposed to competency to waive, right? Being, she's aware, she understands proceedings, but does that go to her competency to waive her right to counsel?
Well, I think the court did probe her competency through asking, about whether mother understood the disadvantage of proceeding without counsel, and asked whether she understood that proceeding with representation that she would have to be responsible for making objections and for questioning witnesses. And each of the questions were answered very coherently. Mother did not appear to be confused or go off on any tangents in responding to the judge's questions during the colloquy. And so I don't think it was unreasonable for the court at that point to not further probe the issue that was raised at the time. The court or the judge was in the best position to determine whether mother appeared to be
Right, but there's these
incompetent.
disconnects because you have mom responding appropriately at times to the judge and to the process, and then you have her statements that are hard to reconcile and understand. I recognize that there's a crisis of CAFA lawyers across the state and in particular in Springfield, Western Mass, but as counsel said, that's not mom's problem. How do you reconcile some of mom's statements about thinking that she was the female Jesus with being able to decide, I'm going to elect to use standby counsel?
I think if we look at the record, clearly, admittedly, mother makes unusual statements in talking about, communicating with paranormal and, receiving numeric messages and other things. However, if we look at the record, what I think comes through, what is pretty clear, and I would direct your honors to the third day of trial in particular, pages 3:5 through 350. And during that part of the transcript, standby counsel indicates that mother has presented standby counsel with a series of questions, and the standby counsel proceeds to conduct a direct of mother, which are the questions that she has provided to counsel. And the direct is very clear, very well organized and structured. Her answers are very clear, and she's extremely articulate in her responses. And that goes on, throughout the direct. And it's only until about the 50th page or so when counsel starts to ask her specifically about her spiritual beliefs. And it's at that point that mother starts to go into some of these unusual beliefs that she has. But she also, during that testimony, indicates that what she describes as spiritual trances that happen, these episodes that happen to her, that those things do not interfere with her daily activities. And the standby counsel asks her, does it interfere with your ability to go shopping? Does it interfere with your ability to do other things? And she says, no, it does not. And on cross-examination as well, a number of the questions are very clear and coherent. It's only when she's asked by other counsel about her spiritual beliefs that she starts to go into explaining.
Of course, we're looking at a cold record. I didn't see anything that suggested that there were inappropriate outbursts or shouting out at witnesses, which sometimes happens in these cases.
No.
There's nothing like that in the record, right?
No, not at all, Your Honor.
So she comported her behavior in the courtroom.
She did. Court made no findings about that at all. And in fact, if a review of this record will clearly show that mother impressively represented herself and coordinated very well with standby counsel throughout the trial, and the court made a finding specifically about that.
Could I just ask, assuming that all of that, that we're on the same page with you about that, I can understand most clearly how that goes to the mother's competency to represent herself. But I'm having a little bit more difficulty pulling back to the point of the waiver of counsel argument, particularly in light of the mother's counsel's argument about the equivocality of the mother's agreement to representing herself. How does what you're talking about here reflect back on that decision?
Well, I think what the court looked at that point, the denial of the motion to withdraw, as Your Honor mentioned earlier, the court said to counsel, indicated to counsel, in addition to the number of options that she was presented with, which actually included the option to hire her own attorney, mother was presented with the opportunity to renew that motion at trial and on the first day of trial. And on that first day of trial, her counsel clearly indicates that mother has requested that I act as standby counsel and that she proceed pro se. And mother confirmed that at that hearing. She did not indicate, that she clearly wanted to have a seventh attorney appointed at that point, didn't indicate that she was somehow opposed to it or objected to it at that point on the first day of trial. And she had the opportunity to do that at that point.
We'll have to leave it there, Mr. Salcido. Thank you very much.
Thank you very much.
Attorney Garov-Wilson.
Good morning, Your Honors. My apologies again for being late.
Oh, no. Don't worry.
To dispel the court's credit that I changed it, I actually didn't. I was able to swap cars, so I was lucky enough.
I would have just said I changed it, but
Well, I was tempted, but I owe candy to the court. So, Your Honors, I represent the two children who are appellees in this matter, and they asked this court, this panel, to affirm the judgment of termination of the parents' parental rights and freeing them for adoption. And before we go any further, I would like to remind the court that my clients, one of them is 10 years old, the other one is just turned 4 in September. They have spent, one of them 6 years in foster care, the other one in her entire life since she was born. This is not harmless. Not having permanency, and they desperately want to be adopted. And I also want to point out, to focus the court's attention to something that Justice Hand mentioned, that this is a actually domestic violence case. This is not a mental health case. The mental health of the parents was not the reason why their parental rights were terminated. They're mentioned only in the context that they were, the way they tie with the parents' inability to stay away from each other and to keep abusing each other. And there's clear and convincing, uncontroverted evidence by both parents. They both admit they have had severe domestic violence arguments, both of them being the aggressors. There are stitches, there are bruised eyes, there are hospitals, police responses. The mother, I believe she drove over father's body. Well, she claims that he rolled over her hood. He claims he hit her when she was angry. So it is very clear that these parents are very, very violent with each other. There is training orders they refuse to abide by. They both claim they're going to co-parent, that they're going to be a family in some sense, that they're married in spiritual sense, and all these things. And the judge found that it was not in the children's best interest to be co-parented by those two volatile, violent parents. Aside from that, talking about the main, the elephant in the room, the mother waiver of counsel. So mother makes the argument that mother did not waive counsel through her conduct. Now the fact that the mother had 6 counsel may or may not suggest impropriety. However, she didn't need to have 6 counsel in order to have waived counsel through her conduct. When her counsel sought to withdraw, and was given the opportunity to have a hearing at the day of trial, she did not have a hearing. Mother did not request a hearing on the reasons why this relationship hadn't worked out. And case law is very clear, Olivia is very clear that just alleging a breakdown in communication is not enough. You have more, you have to elaborate on that. Who had the burden to do that? It was, the burden was on the mother, not the court, to probe the questions of what were the reasons of the breakdown of communication. And I also want to point your attention to mother's standby counsel motion for competency evaluation, where mother's counsel states that she's concerned that mother feels compelled to share her beliefs with this court, and no counsel would allow her to do that, which is true. No trial counsel would allow her to share those beliefs because they may be seen as delusions. Well, if this is the case, what is the point of appointing her 7th counsel or 8th counsel? Nobody would allow her to say what she wants to say. And I suggest to you that that was the real reason why she chose to represent herself, despite having the option of keeping her counsel or
So you think
hiring
it was
her
just
own.
a delay tactic?
I do believe it was a delay tactic, yes.
And what can you point to in the record, other than the succession of appointments and discharge of the prior attorneys? Is there anything else that we can look at to glean that?
Well, so what you can look at is the last day of trial. So if you look at mother's conduct, those 5 days of trial, she's been extremely eloquent and very clear that she's oriented as to what is happening in court. However, the last day she says, oh, I was not clear what's going on. I apologize, I don't have the exact page number, but she started, it seems to me that she was trying to delay further proceedings by, first she agreed to having competency evaluation done, and she made arguments like she's a sovereign citizen, which is, I'm not sure if I don't think I have time to elaborate on what that means and what that group believes and does, but this is a common technique of delay and subvert the court process. I'm not asking you to find that. I mean, the judge didn't find that's what she was doing, but it suggests that she might have been trying to delay the resolution of this case, which again is not harmless. In terms of the denial of competency evaluation, the competency evaluation motion, I would like to point to you that Commonwealth v. Martin states that not every instance of abnormal behavior or sign of mental disorder constitutes a sufficient basis to trigger the hearing requirement. And yes, her beliefs were unusual. Whether or not they're delusional, I think this is a slippery slope, because the judge said her beliefs are her beliefs. It's Commonwealth v. Martin.
35 Mass Ave?
35
Okay.
Mass Ave, yes, 9698. So it is clear that she's exhibited abnormal behaviors in the past. She admitted to it. She's been screaming, robotically dancing, and very, very strange things. She didn't do any of those at trial. As a matter of fact, the judge made finding on the record that she was very well oriented, and even her mother's own standby counsel recognized that she has asked pointed questions. She had made objections that would have put probably first-year litigant me to shame, the way she objected on not just hearsay, but also argumentative. When DCF tried to ask a question regarding the child's opinions, she made an opinion objection, which for somebody who doesn't have formal training, it means that either her standby counsel prepared her really well, or that she was prepared enough to represent herself. And yes.
Can I ask you a question? Do you think the same standard that apply, the same rules, standards, procedures that apply for in a criminal case when a defendant is going through counsel, is asked for their seventh counsel, did the same factors apply in a care protection or termination case?
Case law says that they do, Your Honor.
Okay.
Yes. So again, it is, sorry, I'm almost running out of time, so I'm going to rest on my brief. My apologies.
No
I'm going to rest on my brief, and again, ask on behalf of my clients for the judgment to be affirmed, and then be freed for adoption by the current placement. Thank you.
Thank you to all counsel. The case has been deemed submitted. I'm waiting for people to come in. Last but definitely not least. Thank you. It's always good to have a good trust case before lunch. Squas, I'm sorry if I mispronounced that, versus Carol Ann Fillardo and others. Docket number 22P1118. Mr. Nina?
Excuse me. Members of the panel, may it please the court, my name is Frank Meaner and I'm counsel for Carol Fillardo. This case was set in motion with the trustee of the Mario R. Fillardo Trust filing a contempt complaint against Carol Fillardo. Carol Fillardo is the wife of the settlor of the Mario R. Fillardo 2003 Trust.
So could I I ask you a question about, it's a math problem, which I know as lawyers we don't really like to deal with, but is your argument that she's essentially being required to pay the $126,606 twice?
Yes, Your Honor.
And that is because, correct me where I'm wrong, in the first instance, when the parties entered the STIP, the $126,606 was to be credited against her ultimate share. And then when the trustee brought the contempt, the judge ordered $126,606 to be paid.
That's correct, Your Honor.
What do we have in the record that shows us that the first $126,606 stemming from the June 2018 STIP was actually credited? Is there an accounting that shows that?
There is, Your Honor, and actually it was supplied by the brief for the appellees.
So
I
where
believe
is
in
it
one
in
of
the
the
record?
exhibits. I don't know if I have that.
So you didn't supply it?
I didn't supply it, it's their burden.
Well, you're the appellant, so it's
Yes.
your burden to put the record together.
Yes, Your Honor.
And I don't see, and I'm happy to be wrong, I don't see a supplemental appendix filed by the
No,
appellee.
it was a part of their brief itself.
Okay, so your suggestion is that there's at the end of their brief, there is something called Exhibit 1.
Yes, Your Honor.
Okay, so again, I'm a lawyer, not a mathematician.
Yes.
Could you show me where the $126,606 was credited as against your client's share following the June 2018 stipulation?
Yes, Your Honor, if I may have a moment.
Because what I see is a list of expenses
Yes.
paid by the trust for various
Yes,
things.
Your Honor. And there is the testimony of trustees' counsel in the appendix, volume 5, page 64, that trustees' counsel says, Your Honor, those expenses were incurred in the course of the prior litigation. As with all trusts, the fees and expenses were paid out of the trust during the course of litigation, which ended in 2018.
Right, so I take that to mean there was ongoing income and expenses, as most trusts hopefully have, and that at the time of June 13, 2018, these were the expenses that had been paid from the principal of the trust, and that the parties agreed how each of the four parties, to use that word twice in a sentence, were going to be responsible for those. And because your client didn't have, this client, Carol,
Yes, Your Honor.
no disrespect, but they all have the same last name on your side of the V. Carol didn't have the cash, if you will, to pay the $126,606, so the trust says, fine, we're going to give you, that's going to be a credit against your final distribution.
I would go further than that,
Okay,
Your
tell
Honor,
me.
if I may. A good, probably, analogy to this would be when, you have a bank account and the bank charges a monthly fee. It comes right out of your account at that point in time. So at that point in time, you say, what's in my account? It's less that bank charge fee.
Sure.
And same here. The share, since the only beneficiary that's share was reduced by expenses is a remainder man beneficiary, and there's only one remainder man beneficiary in this case, and that's Carol Filardo. When the trustee pays an expense, at the time of paying that expense, there has to be somebody who actually bears that expense, and that person, that beneficiary, was Carol Filardo.
But if you say she's being disproportionately responsible for the expenses of the trust, that was an issue to raise prior to the stipulation that ended in a final judgment in June of 2018.
Oh, I'm not saying she was disproportionately charged, Your Honor.
But you are saying she's being charged twice.
Twice. Once when the fees were paid and her share was reduced because there's less money in the trust.
So where do we see that? I don't see the bookkeeping, if you will, that said Carol Ann was entitled to $500,000, but now we have this order from June 18th, we're going to minus $126,606, so now her new balance is X.
I think it's also in one of my briefs that I submitted with the court. I'm sorry, I just don't have my hand on it. But there was a place where I submitted the portions of the accounting dealing with the expenses that they were paid.
I don't think anybody's questioning that the expenses through June 13, 2018 were paid. I think, I could very well be wrong, that the question is, how do the four entities, WTS, Mimi, Ashley, Marco, and Carol, how are they responsible for what the trust has paid to date? Some of them reimbursed the trust with cash. Your client, Carol, couldn't afford to do so, so they're going to take a claim as against her share of the estate. That makes perfect sense to me.
Yes, Your Honor.
So the expenses were already incurred and paid. I read this as a bookkeeping method of figuring out who's going to get dinged for how much.
Correct, Your Honor.
Okay.
And so since she is the only remainder man or residuary beneficiary, and that's in the record by trustees counsel at the hearing where trustees counsel says, Your Honor, I haven't answered the question, I'm sorry. There was nothing on Marco's side to set it off against, and here's the important, he is not a remainder beneficiary, only Ms. Carol Ann Filardo is. So only Carol Filardo is the only remainder man beneficiary. That makes her the only one that has a reduction in her share for any expenses paid.
So the fact of the payment of the expense, I'm sorry to interrupt you, but the fact that the expense was paid and Carol's the only remainder person means that she doesn't need to reimburse the trust for that amount because it was already taken.
That's correct, because her wealth has already been decreased and it's in accordance with the stipulation as to what occurred.
So what happened to the money that WTS, Mimi, and Marco paid? That's 75%. Where is that?
That obviously came back. They paid that all back to the trust, and then after July or June 13th, 2018, the date of the final judgment, the trustee then incurred more expenses.
Well, sure, but that's not what's before us today.
And reduced for those payments in, you're asking where those payments in, where they went into the trust, and then were then again utilized and by the trustee. I don't know how else to say it, but the trustee utilized all of those hundreds of thousands of dollars of expenses.
Because it was illiquid, right? There was real estate that would have had to have been sold, as I understand
yes,
it?
only in May of 2021,
right.
Not in June of 13th, 2018.
So the three of the four reimbursed the trust. Carol can't afford to reimburse it. So that money goes back in to reimburse the expenses, and then the trust continues to do what the trust does.
Yes, but Carol has lost, that her beneficial share is forever reduced. It doesn't, nowhere did they re-up her share.
So I want to maybe approach a slightly different way. I mean, when we say the trust, there's not just one trust, right? I mean, there's
That's
a
correct,
jillion
right.
trusts here. There's
Yes.
a marital trust and a family trust and a Marco trust and a WT. Is WT?
Yeah, there's some special separate trusts, yes, Your Honor.
Yeah, and then the exhibit you pointed us to at the end of the appellee brief, those are being paid from the administrative trust account.
Which is the Marco Filardo 2003 trust. It's the larger
Whole thing.
sort of the overall shell, and then these other trusts are funded through that one, what we call
she's not entitled
administrative
to
trust.
all of the money that's in the trust. She's only entitled to a fraction of the money.
She's entitled to whatever is left of all of the trust. She's entitled to what's left. For example,
I mean, is that because the marital? It defines that the marital trust gets everything that's left.
Yes, Your Honor, and the trustee agrees with that. The trustee hasn't disputed that. A good example is there was a condominium involved that was specifically given to Marco, It's not part of the residuary beneficiary. It was not assessed any of the fees because of Marco being a specific beneficiary. It's just not, because it's a specific request. There's a statute, and I can't cite it, I'm sorry, for wills that also says this rule very clearly that, you know, residuary beneficiaries or remainderment beneficiaries absorb the costs of the estate, all of the costs, and only specific beneficiaries do when at a point that there is no residuary beneficiary share left, when it becomes zero. And I don't have that cite, and I didn't use it because it specifically pertains to wills, but it also, you know, by analogy,
Can I ask you, you mentioned when Judge Blake just asked you about the assets being, one of the assets being condominium, and you said that was in 2021, that wasn't in 2018. What I think you're suggesting is that back in 2018, there was cash available.
Yes, Your Honor, there was. There was there was over $1 million in cash in 2018.
And I mean, and the trust is going to pay Marco $1 million on 10/15/2018.
It did pay $1 million to Marco as trustee of the marital trust, as a partial distribution, with the marital trust being the only thing left as a remainderment trust.
And so, I mean, you can see us here. We're here. We're trying to.
I understand it's not easy.
Figure it out. We're trying to do the math. Maybe, I mean, and maybe this is a question for counsel for the trustee, but should we be doing the math, or should we be sending this down to the probate court to do the math?
Well, if the record doesn't have sufficient math to be able to come to the finding that the probate came, then possibly one of the right remedies would be to send it back to get that math.
Well, nobody's disputing the figure of 126,606. I think you're just saying your client was charged twice for it.
Yes, Your Honor, by way of the contempt order, the order in reaction to the contempt. She paid it once back in 2018 when those expenses were incurred. Her share automatically shrinks. She's incurred that, and that never comes back.
We don't have that in the record, right?
I think there is evidence that the trustee made all and there's testimony by trustee counsel.
I assume the trust does annual accountings at a minimum.
Yes, they do, Your Honor.
And so is there some place on the ledger that says negative 126,606 to Carol?
No, there isn't, Your Honor, because the accounting doesn't show the beneficial share sides. It only shows assets beginning.
Is there a schedule of beneficiaries that shows negative 12606?
No, Your Honor. The trustee never produced such a schedule.
I mean, there's also in the judge's order. It says that it is represented that Carol Ann Filardo may also set off her obligation against the trust assets. Trustee contends she has insufficient assets. Trustee may set off her share against her assets, and any deficiency is to be paid by Carol.
But it was already set off once before when the payments were made. And I'm trying to go from recollection. The trustee accounting may have at some point in time reflected that the trustee considered that the 126 was still owed.
So that's what's so important here, because if you're saying she's being charged twice for the stipulation in June of 2018, I'm trying to find support for that argument. She shouldn't pay it twice under the terms of the stipulation.
Right. Yes, Your Honor. And it just becomes a mechanic like your bank account. When you go and look at your bank account and you say, by gosh, I had $1,000 in, the bank took $5, paid $5, right, as an expense. I now have, you know, whatever it is, $95, whatever the, minus the $5 expense in my account. That's, her account was reduced when those expenses are paid.
I think we're going to have to leave it there.
Okay. Thank you, Your Honor.
Attorney Swerbalis.
Good morning. May it please the court, Mark Swerbalis here for the trustee Scott Squilllace. Addressing the question from the panel, is there any evidence in the record of whether the $126,606 was set off or allocated against Carol Filardo's share? The answer is no, because it was not set off or allocated against her share at the time of the June 2018 judgment.
Why not?
Because that is something that would happen in a final accounting, right? In the final accounting, what the trustee would do, what trustees typically do, is if there is an amount owed by the beneficiary and a distribution is going to be going to the beneficiary, the trustee, in addition to the cash distribution or whatever the asset might be, will also distribute the debt, the receivable. Sometimes that...
So until the trust is wound down, you don't carry it on the books.
Correct, Your Honor. And there is no accounting, and this is beyond the record, but in response to your question, there is no accounting that for the trust issued on an annual basis that has ever showed that $126,000 having been credited.
So you agree she doesn't pay it twice?
She does not pay it twice.
He agrees with that.
She hasn't paid it once yet.
So I feel like this is just simply a bookkeeping problem.
It is, Your Honor. It is, Your Honor. And it's interesting because the question of the allocation, Mr. Meaner, Carol Filardo, they argue that the offset against her trust share was automatic, right? They use this word automatic. If the allocation were to be automatic, then the stipulation for entry of final judgment should have said so. That stipulation was drafted by counsel for the parties, including...
Well, but there's handwritten interlineations and changes on it, so we're not going to construe it against anybody. It looks like a group effort, right?
It was a group effort, Your Honor, but my...
Right. So you think that if that was to be the case, that it would be reflected in what's at record 12 and 13?
Which is the stipulation for entry of final judgment?
Yes.
Yes, Your Honor.
I think we're in volume, I gotta
Right.
check. We're in volume 5. Okay.
Right, and what the stipulation for entry of final judgment does is it treats essentially two classes of payors. The first class is WTS and Mimi Ashley.
S, not F.
Who are to make their cash payments within 30 days. The second class of payors is made up of Marco Filardo and Carol Filardo, both of whom, and this is underlining the word both of whom were remainder beneficiaries of the trust.
Of which trust?
So the way the trust works is the trust itself is split up among several volumes of the record. I believe it's volumes 2, 3, and 4. The way the trust works is that when the settlor Mario Filardo died, something called the administrative trust was created. Mr. Squilllace is the trustee of the administrative trust. The purpose of the administrative trust is to collect the assets, pay expenses during...
That's different than the Mario R. Filardo 2003 trust.
It's part of. So under the Mario Filardo trust, it's an umbrella, right?
Mario 2003 is the umbrella.
It's the umbrella. And then
Administrative is underneath it.
administrative is underneath it. The administrative then gets distributed out to several trusts, right? So we had the WTS trust for the benefit of Marco, the WTS trust for the benefit of Mimi Ashley. We have the marital trust. Actually, there are two marital trusts. We have the family trust. And then after Carol Filardo dies, her son, Marco, who is the trustee of the marital trust, whatever remains in the marital trust and the family trust then moves over to the trust for the benefit of Marco, Article 10.
That's an AB trust.
It's an AB, but a little bit more complicated. Okay. Yes, Your Honor. But so Mr. Meaner's notion, so this is a lot of trust stuff.
I'm not allowed to ask the judge question, but AB is?
It's the marital and the family pour over. But so
Let me ask counsel, what's an AB trust?
Of the marital.
She's exactly right. So it's a standard form of estate planning where essentially upon one spouse's death, the assets are split for the surviving spouse into a marital trust, Trust A, and a family trust, Trust B. The surviving spouse is entitled to distributions of income and sometimes, in different variations, distributions of principal during her lifetime. When he or she passes away, the surviving spouse passes away, then whatever remains goes typically to the children. And this highlights sort of something, a contextual point that is in the record but doesn't necessarily jump out of the record. Mario Filardo, the settlor of the trust, the gentleman who created this trust, he created it for the benefit of three beneficiaries: his son, Marco Filardo, his wife, Carol Filardo, and a woman whom Carol Filardo refers to in her papers as his mistress, Mimi Ashley. So there is built-in tension among these beneficiaries.
That was not lost on me.
There has been disputes, controversies, litigation, and this trustee is effectively caught in the crossfire.
But when counsel says Carol is the sole remainder woman, of which trust?
So he must be confining that argument to the marital trust.
So if there had been a bookkeeping record and you had done minus 126,606 to Carol, that would have come out of the A trust, right?
It would have come out of the A trust.
And so if she, and I wish no ill will, if she passed away, there was nothing left in the trust except for the 126,606 debt, would it go into the B trust and then be an obligation of the family trust?
It wouldn't be an obligation of the family trust. It would be arguably, and this is an interesting question, arguably a right of recovery by the trustee of the family trust against the marital trust.
Okay.
Although the trustee's been paid, right? The trustee's been paid out of the trust assets.
Say that again, I'm sorry?
The trustee has been paid out of the trust assets. This is to try and
I
get
believe
those-
the trustee was paid a long time ago.
Right.
I don't believe the trustee has been paid anything in a long time. So here, one of the obvious questions that at least is begging in my mind is, well, if this bookkeeping entry could be made in the final accounting, why hasn't there been a final accounting? Why is this trustee, who's the trustee of the administrative trust, still in office? And the answer is because this trustee has been sued by Marco Filardo for removal and alleged breaches of fiduciary duty. This trustee and the administrative trust face a potential tax liability, which is the subject of separate litigation in Suffolk Superior Court between Marco Filardo and Mimi Ashley.
So you can't wind it down?
We can't wind it down yet. And one of the interesting things here is, so I was referring before to essentially two classes of payors under the judgment. The second class consists of Marco Filardo and Carol Filardo. Marco Filardo, and the language is exactly the same, addressing both of them together. Marco Filardo has accepted Judge Moriarty, the probate court judge's interpretation of her own judgment that she's interpreting.
He's paid the money. He's
paid the money. So, and Mr. Meaner, to my left, represents both Marco Filardo and Carol Filardo.
So if the intent was to reduce Carol's share upon the debit or credit of the 126,606, that should have been contained within the stip for judgment.
Yes, Your Honor.
And it wasn't, so we can infer from that her standing as to the A trust before that stipulation and after the stipulation stays the same, with the exception that she owes it 126,606.
Correct. She still owes that 126,606.
Although it says it shall be allocated to the respective trust share. Or.
Or. It's an and or, because it contemplated.
At the and.
Well, it
That would be
could
double.
You could do it in pieces, I
You
guess.
could be, Your Honor. So, for example, she owed $126,606. She might have paid $26,000 of that in cash. The remainder would be allocated against her trust share. The fact of the matter is, what the record shows, or what the record doesn't show, is that there was never any cash payment, never any allocation, because there wasn't.
If she pays this back in, is she ultimately going to get it back out?
It depends, Your Honor, right? So right now, there are ongoing administrative expenses of the trust. And so the irony of all of this is that the judgment in June of 2018, at least from the trustee's perspective, was supposed to put all issues to bed, right? It was after that judgment, right, which included broad mutual general releases, typical settlement stuff. It was after that judgment in June of 2018 that the trustee received an amended K-1 from WTS's accountant that was allocating $600,000 of previously undisclosed, undiscovered income to the trust, to the administrative trust, as the beneficial owner of the shares of WTS. It was also after that June 2018 judgment that Marco Filardo sued the trustee in probate court seeking removal, asserting claims of breach of fiduciary duty. The probate court judge dismissed some of those claims because they were properly in Superior Court, dismissed other claims because they had already been the subject matter of and released by the prior action. But so the trustee has had to deal with these ongoing administrative expenses, the legal fees, and also has to be prepared for the potential tax liability that may or may not come about as a result of the litigation that's pending in Suffolk Superior Court.
Does it matter that Judge Moriarty's judgment, and this is at volume 5, pages 14 and 15, when she approved the stipulation that she incorporated it and merged it into the judgment, does the merger matter?
I don't believe so, Your Honor.
Because it wouldn't, if it merged, it doesn't retain independent significance as a contract.
But it's still a judgment of the court.
Okay. So if the trust had, at the time of Carol's death, $126,606 in it, and that's the exact amount she owed, it'd be zero that goes into B, and that would be the end. Just to Carol, upon her passing.
If that had happened.
If the trust, is it possible that the trust could actually be negative more than 126 and change at the time of Carol's passing? In other words,
Oh, yes.
because the expenses are growing and the asset is not.
Right now, it's negative, Your Honor. Because of the ongoing litigation against the trust, there is no money to pay those expenses. There is no money to pay those legal fees, something which I know by heart.
So when you say that the trust is illiquid, could you be more specific?
Sure. There is, in the trust today, the administrative trust, there is about $20,000. And there's not more because the illiquid assets, a residential condo, previously a commercial condominium, were distributed to Marco Filardo. There are not more liquid assets because shortly after the June 2018 judgment, Mr. Squilacce, as trustee, and you referenced this before, Your Honor, distributed $1 million to Marco Filardo as trustee of the marital trust. And he did so pursuant to a fairly standard form receipt, release, and indemnification agreement, which says Marco, as trustee, if he receives notice from Mr. Squilacce as the trustee of the administrative trust that he needs some of that money back to pay administrative expenses, Marco Filardo, as the recipient of that $1 million distribution, will pay some of the money back.
That distribution was made in good faith in reliance on the June 2018 judgment.
Presumably, that's where he got the 126,606 when he made his payment.
No, he made his payment just recently. So,
Oh.
so both Marco and Carol opposed
Yeah, please finish your the question.
opposed the contempt complaints. In Judge Moriarty's decision, she denied contempt,
Right.
which, frankly, we think was a gift to them because it saved them 4 years of statutory interest. But she also said that both of them now need to pay the 126,606. They could do it in different ways. Marco, because what was remaining in direct trust for him was the condominium, she laid out a procedure where the condominium could be distributed to him. He could then pull equity out of it to pay his 126,606. Marco, being advised by Mr. Meaner, did just that. Carol, on the other hand, because in her trust share is just in the marital trust, it's cash, she could either try, or actually, to the extent there is any assets in the administrative trust, she could try to offset that. But if the trustee says that there's a deficiency, he's unable to do that, then she owes what is owed. So Marco Filardo paid, complied with Judge Moriarty's April 2022 order. Carol Filardo did not.
So the $1 million that went to Marco as trustee of the marital trust, Carol's a beneficiary of that.
Yes. Carol's the beneficiary of it now, right? Whatever remains after Carol is no longer alive, the beneficiary of that is the current trustee of that share, which is Marco Filardo.
Please do.
Why are you entitled to attorney's fees?
On appeal?
Attorney's fees, right?
We have asked for attorney's fees, Your Honor.
Because you say it's frivolous?
We say it's frivolous.
Going to have to leave it there. Thank you both very much. Very interesting case.
Thank you for all your time.
Absolutely. This will conclude this morning's session. I'd like to thank the court officer, clerk's office, the law clerks, and our wonderful timekeeper. We will stand in recess.
All rise, please.